Sorry. Mention item number 6. Worship, here I am applying for the unit of the
6, I think I have 6.
Worship, here the affidavit is I am applying for the unit of India. Affidavit is ready, but I am waiting for the signature of the concerned officer. So I think that's some time.
You see, it's such a simple issue. When I was reading the
Worship, even without my affidavit,
so where is this commission?
even without my affidavit, the petition maybe can be disposed of. Otherwise, I'm
No, we can do one thing.
I have nothing to say.
We can do one thing. At 1 o'clock, we can go during the lunch time. We can go and see the office of the commission. No, it's okay. No, it's okay. At 1 o'clock, we can just go and visit this commission and come back.
In fact, at present, the commission is located at Dimapur.
We'll go to Dimapur. We'll adjourn the matter for some time.
We have filed an affidavit. Lordship may kindly come to page 20 of my petitioner.
It's not here. You give me a copy. Just let me see that copy. Give me your office copy.
No problem.
Who's for the petitioner?
Your Lordship.
You're there for the petitioner.
Lordship, I just received the affidavit this morning only, so if I. may
You
be
make an
given
inquiry,
some time.
you make the inquiry, ask the petitioner to visit the office and see if it is functioning.
Yes, Your Lordship.
Correct?
Yes, Your Lordship.
So we take it next week, next
Yes, Your Lordship.
Wednesday. Because this photograph which you have produced, it appears that this photograph is only for the court. I have never seen an office like that.
Your Lordship, this is located at Directorate Office.
No, wherever it is. You see, from that photograph, are you convinced that it is working?
Yes, sir.
You are convinced?
Yes.
With that photograph, you are convinced? I don't know. I have never seen a directorate like that.
It's located at Timapur.
No, wherever it is located, it may be at the end of the world. But if it's a food commission office, this photograph does not
Just
visually,
adjacent to the Directorate of the.
this photograph does not visualize any working.
I might be allowed to read my Directorate.
No, paragraph is okay. We are, I am also from your background. I was also a lawyer. We know how to draft. Drafting is an art, we know that.
The position is this. Earlier, the office was located at Rajapoint, Kohima. However, because of the demolition of this building, the one is shifted to Timapur. And the new location is available.
These photographs were taken when maybe when there was a strike call. There's a curfew going on, and the photograph is taken during the curfew point, so curfew time. Does it inspire confidence?
For temporary measures.
No.
Building is.
You see, you have your government of what you call Advocate General's office here.
Yes, ma'am.
You just go there and look at the office and come back. There will be some sort of working in our office. What is this show? The photograph is page 21. In Nagaland, the head of the office, who is the rank of the what you call commissioner, do you think he'll sit in a chair like that? Same chair is there for the officer. There's same chair for the visitor. Do you think in Nagaland there's any officer who does not want to assert his right and sit in a good chair? Any officer, howsoever honest he may be. I think none of the lawyers having chamber will have a chair like that. Look at the chair. Same visitor's chair, same officer's chair. Nobody will sit there. Your commissioner will never come to his office. That is why in the desk, no paper, no files. This commission has absolutely no work. No, we don't have that confidence. Let the petitioner find out. Let the petitioner find out. All sides are duly represented. The learned counsel for the petitioner submit that she has received a copy of the affidavit filed by the respondent numbers 3, 4, and 5 yesterday or today, and she needs some time to obtain instructions. Full stop. court is inclined to permit the petitioner to visit the office of the Nagaland State Food Commission for the purpose of assisting the court. List on next Wednesday.
Yes, Your Lordship.
13th. Next.
May I please, Your Lordships? Lordship, on behalf of N.N. Misra, the appellant from item number 12, 13, and 14. Lordship, it is said that currently in NIA APP is the new APP has replaced the old APP. So there is a transition going on at the moment. That's why on request of the petitioner, if this matter can kindly list it in the first week of April.
On the both sides are represented on the prayer made by the counsel for the appellant. The matter stands adjourned today. List when?
First week of April, Lordship.
List in the first week of April 2024.
Pleasure, Lordship.
These lordships, I beg to mention hearing item 20 to 28. I believe this matter will be listed after 2 weeks.
Why?
After 2 weeks.
Why?
The lordship,
Why are you seeking an
my
adjournment?
senior is in bereavement.
You're for the appellant.
And for the
Respondent.
state is for the appellant.
So
For the
you're
respondent.
for the respondent, okay. Both sides are represented. It is submitted that the learned counsel holding the brief for the respondent is in bereavement. So accordingly, matter stands adjourned today. List after 2 weeks.
Much older.
May I please, Your Lordship? Lordship, I beg to mention on behalf of additional AG, B. Sofred, since she's in the principal seat, item number 8 may be listed after 2 weeks, Your Lordship.
Just a moment in item number 8. Readings are complete.
Yes, Your Lordship.
Readings are complete.
Yes.
Both sides are represented on the prayer made by learned government advocate. The matter stands adjourned today. List after
2 weeks, Your Lordship.
2 weeks.
Lordships, there is an interim.
Okay, interim order passed release stands extended till the next date of listing.
Much obliged.
Your Lordship, also for item number 15 on behalf of B. Sofred, if the matter to be listed next week.
Readings are complete in this matter.
Coming Wednesday.
Lordship,
Yes.
about 1.5 decades, the matter is pending. The issue is with regard to the seniority. And in view of the seniority dispute in the higher level, the lower rank officers are adversely affected. So there is urgency, Lordship. So let it be listed on the next Wednesday as a fixed item. There is some urgency, Lordship.
Okay, all sides are represented. The prayer made by the learned government advocate, the matter stands adjourned today. Next, the learned counsel for the appellant and the private respondents submits that there's an urgency in the matter. And delay in disposal of the matter is adversely affecting various employees in the various officers in the department. Accordingly, while allowing adjournment, it is made clear that no further adjournment will be granted on the next date, based on 13/3/2024.
Suffix item. A suffix
It
item.
will come, it will come.
Lordship, finally, I have a similar prayer for item 29. Last page.
29, somebody has already taken adjournment.
Nine.
Oh, acha, no, it is 28. Okay, 29. In 29 is the service complete?
Yes, this is complete.
You are for the respondent,
Yeah.
but your name is not reflected in the cause list.
I'm representing on behalf of our senior Mojame.
Okay. Both sides are represented on the prayer made by Carl and committed with the matter stands adjourned today. The registry shall reflect the name of counsel for the respondents for listing the matter next. List after 2 weeks.
Your Lordship, if 1 week can be granted.
No, I have no issue with that. Okay, 1 week
Okay, Your Lordship.
after a week.
Okay. Super. Right.
Lordship, item number 16. Lordship, here, affidavit is ready. I'm waiting for the signature of the concerned officer. So I will be given 2 weeks time. I am for the Union of India.
What is the issue here?
Your hepatitis, your lordship is seeking for free treatment of hepatitis disease, your lordship, in this area.
Okay, all sides are represented. On the prayer made by Learned CGC, the matter stands adjourned today to enable him to file a affidavit in opposition in the matter. Next matter. It is submitted that the affidavit in opposition has been prepared and sent for waiting and signature. Next matter. List after 2 weeks.
This is a permanent delay. This is a permanent delay.
Okay, list after 2 weeks. Okay.
Your lordship, I beg to mention item number 17, your lordship. There are my seniors indisposed, so kindly list the matter after 1 week.
What is this PL for?
Your lordship, in this PIL, we're seeking for the benefits under GSSK scheme, your lordship. It's for the pregnant woman, lactating woman, and the newborn babies.
List after how much time?
A week, your lordship.
Just pleading is completed in this
Yes,
case.
your lordship. Pleadings are completed.
It is in the hearing stage only. List after a week is paid, both sides are represented. List after a week is paid for by land counsel to the petitioner. Okay.
Obliged.
Mr. Lordship. Lordship, I'd like to mention for item number 10 and 11. Lordship, these two are analogous mirror. Lordship, in item number 11, I have instruction to give for the respondent number 7.
Ten and 11. We take it up next week.
Lordship, I have to file my affidavit of opposition in item number 11. So I request some time.
May I please, Your Worship? My lord, I am also yet to receive instruction. So kindly allow me 3 weeks time. In item number 12, 11. Item number.
In these matters, what instructions you need?
No, that item number 11 is writ petition.
No, correct. If you have read the brief, what instruction do you require? Have you read the brief and you are asking for adjournment? No, you have not read the brief.
Lordship, in
No,
this
my lord,
case,
in the writ petition, I have not filed affidavit. But yes, in the writ petition, I have not filed affidavit.
So how can you improve in in a rate appeal? You will take a new plea.
no, Lordship, it happened like this. Lordship, in compliance to the judgment in order dated 4/3/2022.
You see, there is a post, and then the person who was appointed was found out to be a non-indigenous Naga.
Yes.
Correct. So in cases of this sort where there is an inquiry and the incumbent has been found to be non-indigenous Naga, what sort of instruction you will get? What sort of affidavit you will file?
Lordship,
By affidavit, you can't make a person who is non-indigenous Naga to be a Naga. The paternity of the incumbent is already on record. So that's why I'm asking. You are seeking an adjournment after reading the brief or without reading the brief? It's a simple question I'm asking.
My lord, in the writ petition, the petitioner to have challenged the cancellation order.
Correct.
Yes.
So we'll have to decide on the basis of materials available on record. The Honorable Judge has already given this finding. You have to just, in an appeal, you have to either attack or to support that finding. How does the pleading change the situation in a case like this? Okay. List after 2 weeks has prayed for, jointly prayed for by counsel for all sides.
Much obliged.
Please, Your Lordships, I beg to mention item number 7. Here I'm for the respondents. I want to file an objection to the additional affidavit filed by the petitioners. So I may be given.
It's a criminal contempt.
Yes, Your Lordship.
Your affidavit is not required.
They have filed an affidavit in opposition.
That's okay, but in a criminal affidavit, it's between the court and the contemner. Your affidavit will not do anything. You tell us what stand you want to take.
I want to object some statements, sir.
We'll take note of that. If you have instructions, you just assist us. It's a criminal contempt. We won't go by your affidavit. If it's a willful and deliberate attempt by the petitioner to mislead the court, we go by that. We'll permit you to assist the court. Next week, whether you file an affidavit or not, we take it up next week. Criminal contempt, we are not adjourning like that. Correct?
Okay.
The petitioner has made out a case that you had misled the court. Now, your affidavit is already on record. Correct?
Yes, Your Lordship.
So, don't think that in a criminal case, in a criminal contempt, you can be permitted to improve by an additional affidavit filed in response to the affidavit filed by the petitioner. But this is now between the court and The contempt
additional-
law.
Lordship, it was filed by them, the additional affidavit.
I know that. It's a criminal contempt. Either you have misled the court or you have not misled the court. That is the only point we have to, so we are not going by the pleadings. Pleadings is merely to assist us, but it's a criminal contempt. Pleadings is not everything.
Lordship, I did
Correct.
to your lordships.
Next week. What says it represented on the prayer made by the counsel for the private respondent, the matter stands adjourned today. List in the next week.
Yes, lordship.
Full stop. Just add that, liberty granted to the private respondent to file affidavit if so advised by them.
May I please, my lords?
Yes.
Lordship, item number 9. Here, reports of service upon the respondent still awaited. So I pray that the matter may be listed after 2 weeks awaiting service report.
This is appealed by the state.
Yes, yes.
You serve it by Dasti. Why so much of time is being taken to serve notice? You are already 569 days delay,
Yes.
and this is pending for how long?
The,
22. Item number 9
item
is a
number
23 matter. 1 year has gone by. So you serve by Dasti. We've seen that this service of notice on respondent number 4 is, sorry, the private respondent is awaited. First of the applicant dash appellant shall take steps within 2 days for service of notice on respondent on the respondent by way of Dasti by routing the process through the registry of the court. And upon service, an affidavit of service shall be filed prior to the next date of listing. Next paragraph, the notice is made returnable on. This is from which place? This is from which place?
Mokokchung.
Mokokchung. You can do it by 3 weeks.
Lordship, please.
Notice, give a date after 3 weeks.
Lordship, if not otherwise, this is the first time coming back that the notice motion is issued. So,
No, you see, 569 days delay. We can't permit you to do more delay.
Lordship, Lordship, Lordship.
The respondent is your employee. You can't serve notice on your employee. Then you're not a good master.
Lordship,
Yeah. 3rd of April, 2024.
For motion, item number 1.
May I please, Lordship? May I please, Lordship? Just like Kevin, I see the copy in the council is also the prisoner. So that may be smooth.
Yes, Lordship, whether this impugned judgment and order they have impugned is even appealable, Lordship.
We'll
Here-
hear you after we hear the appearance. You have filed a caveat.
Yes.
Yes, we'll take note of that.
Hopefully served the copy.
Huh?
We have served the copy also.
It's okay, you start.
The impugned judgment is at page number 213.
Page number 20,
213.
213. Yes,
May I read, Lordship?
yes.
Judgment in order dated 27/2/2024.
Yes.
First, Ms. Swinsu, learned counsel appearing on behalf of the petitioner. Mr. Swinsu, learned CGC for the Respondent Union of India, and Ms. Swinsu.
How do you overcome paragraph 11 and 12?
Yes, sir. Paragraph 11. The learned counsel appearing on behalf of the respondent number 4 and 5, though submitted that at the time of the last day of submission of the application, pursuant to the advertisement dated Swinsu. There was a COVID pandemic, and under such circumstances, the respondent thought it prudent to accept further application, and therefore there was no illegality to so commit. But the question arises as to, without issuing any further advertisement or to a corrigendum thereby, enlarging the period of submission of application, could the respondent authorities enlarge the period of submission of the application and take into consideration an application submitted by the respondent number 5 on 15/9/2021 and 4/12/2021 that do not by post. In the opinion of this court, taking into account that the employment in respect to the post relates to public employment, the said action on the part of the respondent authority in taking into account the application submitted by the respondent number 5, March after 21/3/2022, that too, without any further advertisement or addendum to the advertisement, amount to violation of the rights under Article 14 and 16 of the Constitution. Accordingly, this court in the first with appointment order dated 21/7/2022, insofar as the appointment of the respondent number 5 is concerned. However, this court makes it clear that the appointment in respect of respondent number 4 or others in the notification dated so and so is not interfered with. In the facts of the present case, the direction sought for to appoint the petitioner in lieu of the respondent number 5 does not arise as for the grounds on which the appointment of the respondent number 5 has been set aside. The respondents will be at liberty to take such steps as in the session under law for filling of the resultant vacancy on account of setting aside of the appointment of respondent number 5 as deemed fit. Lordship, the issue involved in this case, it is an admitted fact that the present appellant he submitted his application after the last day fixed in the advertisement. Lordship, may I take lordship to the advertisement? The advertisement is at page number 32 in the memo. The type copy is at page number 33. Page 33. Is an advertisement dated 12 February 2022. Should me read the first paragraph. Applications along with all the relevant documents are invited from ex-servicemen, eligible retired Army, Navy, Air Force Commission officer, and personnel below officers link, so as to reach the undersigned by 21st March 2022.
2020.
In the top.
2020.
Which 33.
This
which is 33 type copy.
2020. It's not 2022. Date is not 2022. It is 2020.
2020. The last date for submission is 21/3/2020. For the employment against the following posts in the Directorate of Senate. Proceed. As per this advertisement, the last date for submission of application was 21/3/2020. But because of the COVID pandemic, the interview could not be held for more than a year and 10 months. The notice for interview. May I take the page number 39. It's a notice for interview dated 25th November 2021.
By any means that Supreme Court judgment in suo moto case number 3 of 2020, it applies to for extension of time. It applies for employment also.
But I'm not sure what it only for condemnation of failure.
Correct. But does it apply for the advertisements issued during COVID time? Will it apply to for it? Does it mean that all advertisement, the last dates given in the advertisement will also be extended.
That I've not understood.
So you see, the government, if they want to accept your application, should have given opportunity to all. How can you be pick and choose then your application be taken up?
But Lordship, one of the grounds which I've taken in this writ petition is, Lordship, due to the COVID pandemic, for more than a year and 10 months, the interview could not be conducted.
No, that is okay.
Thereafter, I've submitted an application.
No, that is okay, but employment advertisements do not get extended. Last date for applying in a employment advertisement does not get extended because of pandemic. Unless the government has taken a policy decision, announced it in the media that all employment advertisements where the last date of applications was during COVID pandemic would stand extended. Everybody must get an opportunity. I don't know if ABC others could have also applied.
I took applied.
So you don't find merit in your appeal, you'll have to dismiss it.
Lordship, as per one of the conditions which is stipulated in the advertisement is that, Lordship, the candidate will go for interview as per the list of empanelment approved by the Kendra Sanic Board. Lordship, what happened was, in the present case, after the notice of interview was issued,
They don't have to apply.
the
People who are empaneled do not have to apply.
no, Lordship, the state, as per the guideline, here's a guideline for recruitment to this post. As per the guideline is this that the state government will forward the name to the Kendra Sanic Board. The final approval will be done by the Kendra Sanic Board. And on the basis of the list approved by the Kendra, only the candidates who are approved by the Kendra Sanic Board should will go for interview. You should become the advertisement condition number 6. The relevant portion is at page number 35 in the type copy. The top condition 8. You should correct the condition number 8 in the page 35.
Yes,
Condition number 8. Should I read it?
yes.
For throwing up the panel of officers, candidates are to register themselves with the Directorate General of Resettlement and ensure that their names are included in the panel for the vacancies prepared by KSP. The KSP is like Kendra Sanic. Only the list of names that are sponsored by Kendra Sanic and duly recommended by DGR shall be considered for the interview and subsequent appointment. For the selection board, names of the officers is not required. This condition is what is stipulated in terms of the guidelines. There's a guideline for recruitment of the officers under the Kendra Sanic.
So, but what is your stand? Are you taking a stand that once there is a list?
Once he accepted the the final list for interview, that was uploaded in the official website. The petitioner has not denied to that effect, to that fact. Yes, accepted that. The list was uploaded in the official website.
No, just tell me, just try to explain it to me. Is it your case that once there is a empaneled list, people outside the empaneled list cannot apply?
They cannot apply.
Okay. Number 2.
No, they cannot apply. Person outside the panel list, they cannot participate in the interview.
Okay. And number 2, people who are in the empaneled list, do they have to apply or they do not have to apply?
Lordship, after the apply, Lordship, may I take Lordship to the guideline? The guideline is at page number 57.
57.
57. This is a guideline on appointment of director, Sanic Welfare Secretary, Raja Sanic Corporation. Worship, for recruitment to the instant post, this guideline is applicable. Worship, the relevant provision is page number 58. Clause 4.
Yes.
Panel of officers, clause 4. The procedure for throwing up the final
No, I don't know this page 57 you are reading.
58, Worship, the relevant.
No, it's
provision is page
okay.
number 50,
It starts from 57.
57.
57 says guidelines of appointment of director, scenic welfare cum secretary.
Yes, Worship.
Now, this advertisement is by Home Department Police B branch for posts which are there,
Yes, Worship.
correct?
Yes, Worship.
Now, this is a post of, you are fighting for a post of director,
Deputy Director, Zilla
deputy
Sainik
deputy
Welfare
director,
Officer.
Zilla Scenic Welfare Board.
Yes, Worship.
Yes, okay.
I take Worship to the clause 4. That is
Yes.
page number 50. Clause 4 is relevant for the present. The procedure for throwing out the panel of officers for appointment to Raja Zilla Sainik Corps, State District Sainik Welfare Officers shall be as follows. Clause 8. The request for panel for the vacancy shall be forwarded by the state government, union territory to the secretary, Kendra Sainik Corps, 2 months prior to the post filing again. Clause 2. The secretary, DSP, will obtain the names of the officers, service personnel from the directorate, general recruitment, placement, seal of the 3 service headquarters, in true of a panel of officers for the vacancies. Number C, the state government may also forward names of locally available officers to Secretary Kendra Sainik Board for inclusion in the panel. Which is important. Who will have it verified from the Directorate General Recruitment Services headquarters on their eligibility for the post and confirm to the state government. The DSP will forward a panel of officers after duly verifying through the concerned state government union authority for further necessary action within 4 weeks from receipt of request from the state union authority. This is the procedure. This is the procedure prescribed for empanelment.
You see, it would be very difficult to accept your argument for a simple reason that not only you, but others also applied.
Yes, sir.
You did not challenge the advertisement that the application should not have been invited at all. It should be limited to only those who are in the empaneled list. Outside that, nobody could have been invited for filling up the post of Deputy Director, Scenic Welfare Board. So once you participated, then possibly you will be prohibited from challenging the procedure, even if it is wrong. You participated.
Yes, Worship, it is my submission, Worship. Worship, after the lockdown was relaxed, I submitted an application to the state government requesting to republish the application, advertisement.
Requesting,
Requesting to advertise the advertisement.
where is your application?
Worship, on page number 114, the affidavit of the affidavit of opposition filed by me. Worship, may come to page number 124. One 24. Worship, this letter was written by one Lieutenant Colonel Chupa Sashi retired. Worship, that is a colleague of the present appellant. And my name figured as serial number 2, Major Maranwati retired. This is the present appellant, Worship.
By reading this, you have demolished your cause. By reading this, you have demolished your cause. In this representation, you are saying that within 2 years' time, more people must have retired. But you applied before that. Your application is, this representation is of 22/11/2021. You applied on 15/9/2021, prior to that. And your second application is 4/12/2021. So in view of your representation that some more people must have retired, the judgment of this court is not required to be interfered with, because it says that you have to re-advertise. You have to go, this,
No, the first application submitted by me.
the ground in which appointment of respondent 5 has been set aside. The respondent would be at liberty to take steps as envisaged for filling up the resultant vacancy. So now they will go as per your representation. They will invite
No,
more applications for people who have retired. They also will get the benefit now.
the first application which I have submitted is at page number 44. That was
Yes.
page number 44.
Yes, that is 15/9/2021.
No, 25/11/2021.
No, you applied twice.
Roship, it had Roship, we come to page number 44. That was
Page number?
Page number 44.
44.
After I submitted a representation, Roship, the respondent authority, they permitted me to submit this application. Page number 44. This was submitted on 25/11/2022.
Yes.
Roship, after this, we can come to. Roship, we come to page number 44. These are part of the report annexed by the petitioner in the registration. We can come to page number 42.
Just a moment.
After I submitted the application on 25th November 2021, the state government have accepted my application. After receipt, in your official website, you have uploaded the list of applicants who have applied for the post.
Where is that?
That is at page number 42.
42.
42. This is a part of the record which by the petitioner in the
Yes.
So the relevant portion, I said page number 43. My name figured at serial number 19 in the bottom. Page number 43. To the remark that discharge book not furnished. It's in the bottom. Serial number 19. The right hand side. In the remark.
42.
Page number 43. Right hand side, page number 42. Serial number 19. In the bottom.
42 in the bottom.
No, page number 43.
43. Okay. Yes.
My name figured as serial number 19.
Yes.
With the remarks showing that discharge book not furnished.
No, you see this name came
Yes, Lordship.
because of page 208.
Yes, Lordship, that I'll come up after this. I'll satisfy the Lordship on this.
So because 208, this is December 2021.
Lordship, page number 208.
This is December 2021. Therefore, your name came into the panel in December 2021 after the closure of the what you call that advertisement.
Lordship, 208.
Because you see, we'll tell you something. Now you see, this list of panel is sent on December 2021. We don't have the date. Now with this panel, nobody in this panel would know when did you apply. Therefore, let us assume that Ms. Zimovi wanted to object to your empanelment, but she could not have done it because of the fact that in this list, which you are showing at page 43, the date of application is not mentioned.
Yes, exactly. The date of application is not mentioned. Lordship.
Then how will I know?
We'll give an opportunity,
No, Lordship,
unless you have to rush out somewhere. We'll give you an opportunity.
Lordship, the default selection process. There's a change in the selection process. You accepted the change in the change of procedure in the selection process. By accepting my name, by empaneling me. Lordship, I'll rely on.
You see, we-
Caused by the export in the similar case.
No, Mr. Ima, we are not, you see, we are not questioning you on anything else. The only answer we require from you is that, you see, in an employment advertisement, there is a last date of application,
Yes, Lordship, but that I admit.
correct? Your application was beyond that.
Beyond that.
So beyond that, the authorities by some order must have kept it open. Because otherwise, you see, what will happen is that it will be leading to anarchy. And if it gets a seal of approval of the court, that means the date of application, last date of application will carry no meaning. Because everybody will say that no, High Court has given a seal of approval, it can be done anytime. You see, the authorities may take time to make an employment. But the question is that everybody should get an equal opportunity. Your representation also says so.
After the advertisement, there was no advertisement for a year and 10 months. That is a long period.
But nobody challenged that.
Nobody challenged.
You could have also challenged that now, since this, it has not been, the advertisement has not been put to quietus. Please permit us to participate. So that was also not there, but after the due date, if you can show me any authority on the point that the advertisement
Lordship, yes.
can be kept open.
Lordship, I'm relying on two judgments. In the two judgments, there's a variation in the criteria which has been prescribed in the advertisement.
Shows that.
But when the petition person, after knowing the change of procedure, if he participated in the selection process, he cannot turn around and challenge the selection process. That is the two judgment I'm relying. I mean, first refer to page 2009, volume 3, SEC. 2009, volume 3, SEC, page 227. This is a case which arose from the state of Assam, and it ended up in the Supreme Court. Here, the principle in this judgment is, after having accepted the change in the selection process, one cannot turn around and challenge the selection process. That is the principle in this case. So I'll take your worship only the relevant portion, relevant paragraphs, which starts from paragraph number 26 up to 32.
Just a moment before you read this paragraph. Now, who has challenged the selection process?
Here, the selection process was challenged by.
No, not in this case.
Yes.
In your case. In my case,
also unsuccessful candidate. She was also a candidate in the selection process.
So she made the challenge.
She challenged my appointment only. My selection of my.
So this answers your statement, answers this judgment you are relying on, because she is not challenging the recruitment process. She is challenging your appointment.
No. She's challenging the recruitment process also. She's saying that after the last date of submission of application, I cannot be allowed to. That is the issue.
You cannot be permitted. She is not challenging the advertisement as such. Recruitment process is not being challenged. It is the selection which is being challenged. Selection and recruitment process are two different things.
And now, in the present case, in my case, I submitted my application after the last date of submission. However, on the person to the presentation submitted by me, the state respondent.
Okay, let us say one thing. Let us say that this scenic board can be only manned by persons from the empaneled list. Correct? We take your argument. It can only be from the empaneled list. Now, what I do is, I am class 8 pass. I don't have any background of what you call military service or army service. I am merely working as a peon of the what you call the let us say CDS. And because of that background, I apply for Deputy Director, Signing Board, and I get selected. Correct. Now to challenge my appointment, if I accept your submission, is that we are challenging the selection process.
Worship, you're challenging the selection process. Worship, on the
No, I'm
ground
giving
that-
you an example.
Yes, Worship, right, Worship.
There are three classes, good, bad, and ugly. My example is an ugly one. So I don't have that qualification. And if I am selected without qualification, and if somebody challenges that appointment, according to you, it will be challenging the selection process, not my appointment.
Worship, in the present case, the petitioner, they are not challenging about the qualification or the eligibility of the qualification. They're just challenge against me is that since I've submitted my application after the last year of submission of form in the as per advertisement.
So we take it from the bar that the law which will be prevailing henceforth is that the last date carries no meaning.
Worship, the law to be applied in the present case according to me, Worship. Since I was permitted to participate in the.
I was also allowed. I am class 8. I have no military background. I am just bungalow peon of the CDS. That is my only qualification. And I applied. I was permitted to participate. My application was accepted without any protest.
Worship,
Nobody in the world came to know that I am not qualified to even be empaneled. And nobody could object because the list which was printed did not give my qualification. My class 8 pass, my non-military background, those are not there in the empaneled list. So therefore, if I am selected, according to you, nobody can now challenge it.
Worship, my submission is Worship. Last date of submission was Worship, the last date of submission was 21st March 2022. However, the state respondent due to the COVID pandemic did not conduct the interview. So subsequently,
there is another principle, Mr. Lima.
yes,
That principle is principle of seeking compensation. You can file a civil suit against the authorities who have permitted you to apply and then get benefit.
Worship, by accepting my application and changing the criteria which has been stipulated in advertisement, that is a change in the selection process. And by that change of selection process, I was allowed to participate in the interview.
That can be done without any advertisement.
No, when there's a change in the selection process, when he accepted the change of procedure in the selection process.
She accepted.
Yes, that's my problem. Can kindly come to the list of panel. That is page number 87. No,
Just a moment.
just page number 87.
Just a moment.
This letter dated 9 December 2021, issued by the Kendra Senate Court. This is a list of the panel requesting the state government to conduct the interview on the basis of this list. I'm allowed to read this letter.
Page
Page 87.
87.
By this letter, the selection process has been entirely changed, in which the writ petitioner has failed to challenge this. She has not challenged even this letter in the writ petition.
Oh, you are pushing us too hard. This letter was served on her.
So this was in the official website. On the basis of this list.
This letter is in website.
Yes,
I can check it. I can check it right
It
now.
was in the official website.
I can check it right now. Which website?
It's in the top. In this letter, the website.
Which site?
Page number 87.
I'm there at page 187.
In the top.
Top is a mail ID. Mail ID is not website. I'm giving you a tab. This is equipped with net. You just find out from the website. You see letter from one department officer to another. It will not be in the website, number one. And number two, you see, we have so many confidential mails coming in my office. Many communications from various courts, various honorable judges, various authorities. They are pushed through emails to us. A lot of mails coming. Now, what I'm trying to ask you from this is, any communication made in email, how in the world would I know, or my brother would know, that Justice Surana is receiving an email, I want to access it, and therefore, since he's a brother and fully, it is at par. He's at par with me. He wanted an access to this email because it affects the institution. And therefore, a private email pushed through an email inbox. I'd love to learn from you how it can be accessed from website, because I want to have his confidential mails read.
Receipt will be in page number 40. This is the official website which you have given. Page number 40.
40.
Yes, receipt. This was annexing the notice for interview. Page number 40. The candidate may visit the site www.nagaland.co. Instead of policies.
400. Candidate may visit www.nagaland.gov.in. Now we'll try to find out from this website this letter. If you can, if you are happy uploaded, your case is admitted. If it is not, we are dismissing it.
Later dated 9.
Yes. Don't worry. www. What was that? Dot.
Nagaland, small n.
Huh?
www.nagaland, small n.
Nagaland. NAGALAND. .gov.in. I gone there. Official portal. That was which page? 40?
Page 40.
40?
Yes.
40.
40.
Now, where is that letter?
The letter is
87.
87.
09. 1. APPT. Nagaland. Zero 09. DEC 21. Search. Doesn't come. This letter doesn't come. And moreover, Mr. Lima, if I have understood things correctly, in my limited understanding which I have, the advertisement must say that for change in policy, please keep on checking the website. The policy of advertisement, the policy of recruitment may change during the currency of advertisement, and therefore please check website. This is something required to be told. And I can tell you, I do access net many often, more often. Because of two reasons. Number one, I rely on e-journals, which is web-based. That's number one. So therefore, I do visit websites. But unless I am notified that please visit that website, it may contain information for you. I don't visit each and every website. Correct. So therefore, if in a recruitment policy of a government, there must be a consistent policy. It is not not the manner of government that one person will have information of what is happening inside the government and the other who is in the queue will not know it. I'm using these words very carefully because you have jumped the queue, you have not come on the last date of advertisement. There is someone known to you or somebody wants to help you, your application was accepted. Whereas if I go and apply, even with my position, after the due date, my application will be rejected, it will not be entered. Even if they come to know that the Honorable High Court Judge is applying, then also after the due date of advertisement, my application will not be taken up, but yours was taken. Now, change in policy is something you will have to demonstrate that Ms. Jimomi had knowledge. If you
Yes,
can
Your
demonstrate that she has knowledge,
Worship, that's why Worship, I was relying on page number 42 and 43. This is a
42.
document next by the writ petitioner in the writ petition. This is your document.
yes,
This is not my document.
yes,
And by this list, that it was you're one trying to project that my candidature has been got rejected. By this page number 43 in the writ petition.
yes.
This is not my documents. These are documents next by them.
Correct.
So by this document, we choose that you receive that my name also figured in the list prior to the interview.
She annexed this document to help you or to challenge this appointment, your appointment.
My appointment, in order to charge my
So
appointment. she
therefore,
annexed this
therefore, you
document
see, this is a document used by her to assail your appointment.
to assume my appointment,
So it doesn't mean that this document is annexed to help you.
not to help me to receive against me.
So that is
So
that.
we choose that receive this document. She was aware that my
No,
name.
she is aware. That is why she is in court. No, no, we have heard you enough. And dismissing the writ appeal.
Lordship,
This is not taking us anywhere. She annexed a document does not mean that this document is to ornament you. This document is not ornamental for you. This is a document based on which she is challenging her appointment. So this is a document used by her to assail your appointment. She is not annexing this document to say that, no, well, I have this information, I did not challenge it, and now belatedly I am challenging it. I have acquiescence to that, that notification. She is not acquiescing.
no, Lordship, the statement of the writ petitioner should become the page number 24, paragraph 7. This is a statement which have stated regarding this annexure F.
Oh.
Annexure F. In the writ petition, page number 24 in the memo of appeal, paragraph 7. This is your statement.
It came to light. That's why she is challenging it.
That it came to light that as per the applicant list issued by respondent, a total of 19 ex-servicemen applied for the post of deputy director Swinson. Wherein the name of the respondent number 4 appeared as serial number 9, petitioner at serial number 15, in the respondent number 5 serial number 19. In the column of the
You omit all those parts in this last two line, and both the respondents are ineligible to be selected. So she is relying on a document to say that you are ineligible. She is not ornamenting you.
It shows that the read petitioner was aware.
Okay, just tell me an oath. I'll ask you to file an affidavit in course of the day. Just tell me that in your career as a lawyer, you have not moved a writ petition by way, after your client has come to know something adverse is happening. So every writ petition you have filed is with prior knowledge of what is wrong. Subsequently, when you want to challenge it, you have not relied on any document in your career which is post what you call digging out of the documents which might have arisen earlier. So you see, if you are under challenge today, there's an order against you. Now you will dig and find out what documents are there to help you in making your challenge. That is how a lawyer makes up a brief. So every adverse, whenever adverse thing happens, you got appointed. That's why she started digging. Is it wrong? It is so hopelessly wrong that we'll dismiss the writ appeal merely because the writ petitioner found out documents favoring her after the event. Is it so bad that everybody must have prior information of what is going to be wrong against him? Somebody has a ration card, not getting a kg of rice. So he or she will have prior information that today when I am going to the PDS shop, I will not be getting 1 kg of rice. It is only when you don't get rice, then you ask, what is the quantity? It says 10 kg quantity is there, rice, and you are not getting it. That's why you are challenging it. If you have every information, then we don't need God. We can rely on you. You have information of everything. We don't need a God then.
No, Roship,
No. It's no. This argument is not taking us anywhere.
No, Roship, my empanelment. If prior to my empanelment in the list, she was aware. Roship, it comes to the page paragraph number E. Para E. Page number 24. Para E. Your statement in the writ petition. Para E. She may read para E.
Please.
Page number 24. Para E. That it also came to light that it was only when the state respondent issued the oversight notice dated 25/11/2021 to conduct inquiry. The respondent number 5 applied for the post of deputy director so by application dated 25/11/2021 in spite of the date of submission having been closed on 21/3/2024 at 4 p.m. and in a lightning manner the next day on 26/11/2021. His file was processed through 4 branches of the department instantly included in the applicant list.
Mr. Lima, let me tell you something. As a lawyer also, you must have known. When I am, every month, there's a roster made of all the honorable judges where they will be sitting. Correct? I get my roster in a sealed envelope. The rosters is made by the Chief Justice, Honorable Chief Justice, and then it is sent to us in a sealed cover. And you see, sealing is done by the Secretariat of the Honorable Chief Justice. And even before that, I get that roster, everybody in the bar knows what is happening, who will be sitting where. Everybody in the bar who is a man of authority, a lawyer of authority, he will know when honorable judges, even if you are not interested in me, but still you will be knowing where Justice Surana will be sitting. That is our that is our secrecy. Correct? No. It doesn't. It's not taking us anywhere. No substantive argument you are making.
Very word which is stated in this paragraph E, in the last 3 paragraphs. His file was processed through 4 branches of the department.
Correct.
In this, that is the statement.
Are you wanting to say that the citizen should not know how the file is being processed?
No, my submission
is it very secret, Official Secrets Act?
No, my submission.
Prosecute her.
If it is in his knowledge, obviously, he was aware about the final empanelment list. he should have, in that case, if he really wants to object my participation in the interview, he should have challenged this final environmental list. He has not challenged. Then he also participated in the interview.
Okay,
So after participating in the interview, now he cannot turn around and challenge my appointment. of-
okay, we accepted. Your argument is accepted, but rejected. Heard. Heard. Oh, yes, I'm so sorry. You will have to argue and support him. Pardon me? Correct. And you are supporting him, Mr. Lima? Not at all. No, no, my brother just reminded me that we have not heard you. As a caveator, we must hear you. And we are expecting that you will support him. No, okay.
I will take my lordship's time because my lordships are not well conversant. Lordship, just to the advertisement, there is not only the last date, but this is the terms and condition. Page 32.
Yes,
Clause 6.
yes.
Simple application in plain paper with following details documents may be submitted by registered post to the undersigned by name so as to reach by 4 p.m. on 21/3/2020. Application. This is the reason why I have noted that. The second is application by hand will not be accepted. Inquiry, that's all. Application by hand will not be accepted within 2 days. This was also violated. He just went and within 2 days, just because they happen to be in a position where I will not express lordship. They cannot do these things in violation of the all other candidates who applied. And by the way, lordship, in February, when this advertisement was made, there is still no COVID. That COVID thing is still on 12 February 2020, when the advertisement was made. COVID was not that, we have been hearing, but COVID has not yet taken those lockdowns or whatever the response.
No, COVID was there, but the
COVID was there, but-
government did not announce a lockdown.
Yes, lordship.
Lockdown was announced on 26th, and from 27th there was a lockdown.
Lordship. March.
I remember these days well because of the fact that I had to organize my marriage ceremony of my elder son was there,
Lordship.
and therefore we had to abandon everything.
Lordship.
So that was on it was on those days. So there I remember these dates
Lordship.
during my lifetime until my memory serves me right.
Lordship. So what has happened is he slept for 1 year and 9 months, then applied the first application. This is in fact very absurd, lordship. Was submitted first application was submitted on 25th November 2021 at annexure page 44. Then his application was
Page
44. His first application, after 1 year and 9 months, he submitted this. After the closing, 1 month and 9 months, 25th November 2021, page 44, he applied for the post. After expiry of 1 year and 9 months. Then his application was rejected because that is at rejected, and then he prayed for
Just-
re-advertisement.
Just. Yes. Page 44, yes.
Yes, then page 43, his name was not recommended. 43. Page number, serial number 19, Lordship.
Yes.
So his name was not recommended because there was no discharge book. He did not furnish his discharge book. Then, after whatever means that I'm not aware, but Lordship, he did something, and then he applied second time. Second application is at page. He has all the freedom, Lordship. No law, no advertisement. So after doing something, he applied on 4th December 2021. Page 137. So this is the second application.
At least you have entertained us.
So the second application is at page 137. Second time applied on 4th December 2021. So, Lordship coming to know of all these things.
Lordship, this page 137, these are rectification letter, which have issued,
Please don't disturb her.
not a fresh application.
Don't disturb her.
Then my lord will kindly come to page 190. This was issued on 7 December 2021. That second application was on the eve of interview. After the interview was published in the newspapers. 190 page. This is from KSB official to Zilla Sainik Board official. 190, Lordship. Lordship, allow me to read out. Respected sir, this is through email. Request for strict adherence to guidelines. Respected sir, I am sending this mail for kind consideration and necessary action, please. As per your guideline published on daily newspaper dated 25th November 2021. A. Any application submitted after 4 p.m. on 21st March 2020 should not be accepted as per the guidelines issued by your kind office. B. Second, this is in conformity with the advertisement. B. Any application submitted by hand or through other channel other than registered post addressed to the undersigned, i.e. Special Secretary to the Government of Nagaland, should not be accepted as per the guidelines issued by your office. So this was issued 4, 5, 6, 7. On the third day after the appellant submitted his second application on 4th December 2021. So this letter is 7th December 2021. So this is strictly in compliance with the advertisement, Lordship. And the appellant submitting that there is a change of selection process. Where is the change of selection process? And this documents was procured not from the website. The one he is saying that I was not recommended. It was after the interview that was procured from the establishment. These are not uploaded in the.
Okay.
I need not submit much, Lordship. There is no reason that I should go further, Lordship. I place my case to your Lordship's diligence. And the appeal itself, Lordship, there is no use wasting time, Lordship, and the appeal may not be admitted. Because no matter what the appellant says, it cannot change the circumstances of the advertisement.
Okay.
Advertisement is the basis of
Mr.
any selection process.
Heard Mr. Dima Wapang, learned counsel for the appellants. Also heard Ms. Z. Jimomi, learned counsel for the private respondent, who has entered appearance by filing caveat. Who is the CGC appearing here?
She will serve the copy.
No, but somebody, no one is there?
That thing only was appearing in the witness.
No. Today, if somebody is not there, we will not record the name. Okay, none appears on call for the. For the respondent numbers 2 to 5. Even state government is not there. You're there
Yes, sir.
for the state. Your name.
Most of them
The learned government advocate appears for respondent number 3,
No.
4, 3 and 4.
3 and 4, yes.
Next paragraph. By filing this intercourt appeal, the appellant was the respondent number 5. In WPC 176 of 2022, has assailed the judgment and order dated 27/2/2024, passed by the Honorable Single Judge of this court in the said WPC 176 of 22. Next paragraph. The rate petition was allowed by the impugned judgment and order on the ground that the respondent authorities had taken into account the applications submitted by the appellant after 4 p.m. on 4 p.m. of 21/3/2021, without any corrigendum at 21/3/2020 is the data, without any corrigendum, And accordingly, the appointment of the appellant as deputy director what is it post deputy director? Huh?
Is it Zilla Sainik Welfare Officer?
Zilla Sainik Welfare Board
Officer. Zilla Sainik Welfare Officer.
officer.
Yeah.
Okay. Was interfered with. Next one. In brief, the submissions of the learned counsel for the appellant to assail the impugned judgment and order is to the effect that that as per the advertisement dated 12/2/2020, the last date of submission of application was 4 p.m. on 21/3/2020, by which applications were invited from ex-servicemen who were otherwise eligible, having retired from Army, Navy, and Air Force as commissioned officers, for filling up various Class 1 gazetted posts in the Directorate of Scenic Welfare and Resettlement, Nagaland. Full stop. It is submitted that during the period of last date of submission of applications, COVID-19 pandemic had set in, and therefore the interview for the selection process could not be conducted for more than a year. Full stop. It is submitted that after the relaxation of the lockdown was made, the appellant submitted his application on 22/11/2021 to the concerned state respondents. Where is that? Your representation of 22/11.
Please, page number 44. 44. No, I'm sorry.
No.
Second
It is not this
application is at page 137.
No. His representation was there
Yes, sir.
to permit
It should become the page number 124.
124. Yes, 124. We'll just take a short break and come back. Give us 5 minutes time.
Five minutes.
Requesting the concerned state respondents to republish the advertisement dated 12/2/2020 on the ground that by passage of time, number of officers might have retired in the meantime and who were otherwise eligible to apply for the post advertised. Full stop. It is submitted that the state government had favorably considered his request and permitted the applicant, the appellant, to submit his candidature. And accordingly, on 25/11/2021, the applicant had applied for the post of post of deputy director. Full stop. It is not in dispute that initially the candidature of the petitioner was not recommended. On the ground that discharge book was not furnished. Full stop. Nonetheless,
Appellant, Lordship, appellant.
appellant,
Because I am the
appellant, I'm sorry. Appellant. However, it is submitted that the second application of the appellant, which was made on 3/12/2021, was accepted, and the list of
Page 30, 138.
it was on 4th.
Should be a C.
Second application was made on 3/12/21.
Second application was 4 December.
Oh, so 4 December. 4 December, not 3/12. 4 December 2021.
Page 137.
137.
Page, yes. Second application.
No, this is not 4, it is 3.
Should be the top in the right hand side. Dated 4th December 2021.
In the
Above,
In the top.
at the top. 4 December 2021. annexure
No, just on, just.
7.
Just.
This application was submitted as per the condition number 2 in the notice for interview. In the notice for interview, it was the
No, just-
petitioners were
just
given
a
the opportunity to submit application.
Second application, 137.
Something is wrong. Something is wrong. You see, please jutexpose page 137 with page 207. Two zero seven is the empanel list. This was on 312.
Worship, no, 207, this is the additional name forwarded by the state government to the Kindra Sanipur.
Aha.
Additional name forwarded by the state government to the Kindra Sanipur.
You see, your name is there at page 212. This is a part of this list.
Even 207.
212 is an extension of 207.
213. The 212 is an extension of this.
Correct. So you see, you apply on 412, your name is recommended on 312. How it can happen?
No, Roship.
Exactly.
No, Roship, I think this later did 3 here 3/12/2020. Roship, these are wrong. Roship, if you see this later again, later dated. Roship, final empanelment list.
You see this affidavit.
Roship, the final empanelment list is at page 44. I know the affidavit this has been next. So if you see page number 143. Here the inter-standing code is
Page 40,
page 143.
143.
This is the final empanelment list. Question number 1. Refer to your letter number 4 dated 4th December 2021.
Lordship, if we go by this,
Should we see page number 1207 in 130? These are the same letter.
Okay.
Same letter number.
Full stop. It is it is projected that on 4/12/2021, the name of the appellant along with others were forwarded to the Kendriya Sainik Board and by a communication dated 9/12/2021, the name of the appellant was recommended as a person qualified to be considered for the post of secretary, Zilla Sainik Welfare Organization, officer post.
Deputy Director, Lordship.
I don't know, you made me read 143. In 143 said who qualify ab initio to be considered for secretary. Page 143. This is the recommendation. Correct. Full stop. Thereafter, the appellant therefore, after the interview was conducted on 13/12/2021, and the appellant came out successful and was appointed to the post of Deputy Director, Zilla Sainik Welfare Officer by notification dated 21/7/2022. Next paragraph. It has been submitted that the appellant had the knowledge of the change in the selection criteria and the change in the selection process, as well as the recommendation of the name of the appellant as one of the candidates for the grade 1 post advertised. And accordingly, it is submitted that as the appellant did not challenge the selection process, it amounted to acceptance of the change in the selection process, and therefore the private respondent was stopped from challenging the selection and appointment of the appellant. Stop. Next paragraph. It is also contended that the learned single judge had failed to appreciate that the private respondent, having participated in the selection process, could not have turned around and assailed the selection process. And therefore, it is submitted that the challenge to the appointment of the appellant was not maintainable at the threshold. And therefore, the impugned judgment and order is not sustainable. The learned counsel for the respondent number 1 caveator has submitted that the employment advertisement contained a guideline that the applications should be applications on plain paper should be submitted so as to reach the Special Secretary to the Government of Nagaland, Home Department, Police B branch by registered post before 4 p.m. on 21/3/2020. Stop. It was submitted that there was no advertisement relaxing the said condition, and therefore as there is nothing on record to show that the applicant had sent the application by registered post, the respondent authorities had accepted the application made by the appellant by hand. After the due date of last day, after the last date of submission. Accordingly, it is submitted that the application of the appellant submitted on 25/11/2021 was much beyond the last date of applying. She is asserted that initially the name of the appellant was not recommended. But his second application dated 3/12/2020 was submitted by hand was entertained. And the name of the appellant was entered in the empaneled list. And accordingly, she has made her submissions to support the judgment impugned in this present appeal. Next para. On a consideration of the materials available on record. No, just during the submission of Mr. Lima, please add that in support of his submissions, the counsel for the appellant has placed reliance on the case of Amlan Jyoti, AMLAN, next word Jyoti, JYOTI, third word is Borua, BOROOAH, Borua, versus State of Assam and others, comma, within bracket 2009, bracket close 3 SCC 227. First of the said case was cited that a candidate who had appeared in the recruitment process could not have sealed the selection process. Next.
Under judgment from the.
Yes. As well as the case of Madras Institute of Development Studies and another versus K full stop Shiva Subramanian. I am giving the spelling SIVASUBRAMANIYAN and others, comma, within bracket 2016, bracket close 1 SCC 454. Which is also on the point that unsuccessful candidate is not permitted to challenge the selection process.
The issue was, even if the selection was done, not strictly in compliance with advertisement, when a candidate participates, he cannot turn around and challenge the selection process.
Okay, right that. Right, same thing. Just repeat that. Repeat your statement. Please write that.
Para 3, the judgment.
Para 3.
That is the issue.
Oh, okay, but on the point that even if the selection was not done strictly as per the qualifications, mentioned in the advertisement, after being unsuccessful, the appellant was, the affected candidate was in knowledge of the change criteria, was stopped from challenging the recruitment process. Okay.
But this is not about qualification.
Uh, We have given an anxious thought on the rival submissions made at the bar, and also considered the two cases cited by the learned counsel for the appellant. Next para. The employment advertisement, which was published on 12/2/2020, clearly laid down the criteria of applying. And in clause 6 of the said advertisement, it was provided that provided as follows, then give inverted comma, simple application in plain paper with following details, documents may be submitted by registered post to the undersigned by name so as to reach by 4 p.m. on 21/3/2020, full stop. Application by hand will not be accepted, full stop. Inquiry regarding result of application will not be entertained, and canvassing in any form will disqualify for empanelment. Then give dot dot and then inverted comma closed. Full stop. The appellant is not, in the next para, the appellant has not enclosed any document in this memo of appeal to project that the advertising authority had issued any corrigendum to extend the last date of submission of application. Full stop. There is also no material on record to show that the respondent authorities had relaxed the condition that application can be sent only by registered post, by permitting applications to be received by hand. Full stop. The learned counsel for the respondent, respondent 1, has referred to document at page 190 of the memo appeal, which is a email from Director General Resettlement. What is this office? Director General Resettlement, Government of India.
Yes, yes, Lordship.
The Government of India. To the, this is to whom? What is the name of this office?
SH Nagaland.
AODGR, Director General Resettlement.
SSH. Nagaland. That is.
Wrote to one Gaurav Mehra at the email address of AODGR, all small, AODGR @ small DESW.gov.in.
Lordship, this is to ssh.nagaland@gmail.com. This is
Oh, down below, this one.
to, yeah, this is copy.
Acha, acha.
To SS, this is.
Acha, this is,
something step.
No, you just copy this, huh? Page 190. I've given a tick mark from pencil, copy from this to this.
SSH, yes.
So they said letter is quoted, they said email letter is quoted below. Full stop. This quote, the London single judge of this court had assigned reason in the impugn order, impugn judgment, that admittedly the appellant herein had not submitted the application within 21/3/2020, but application was submitted on 25/11/2021, followed up with another application dated 4/12/2021. Where is this 4/12/2021? (137). This court has also, the London single judge has also taken note of the fact that in the application dated 4/12/2021 by the appellant, it was mentioned therein that the appellant was found ineligible with a remark of discharge book not furnished. This will be in inverted comma, discharge book not furnished, inverted comma closed. Full stop.
I beg your pardon, Lordship. SSH is Special Secretary Home.
Acha.
That was sent to Special
Okay.
Secretary.
Full stop. Therefore, it appears that upon that after rejection of of the candidature of the appellant, holding him ineligible, comma, the Special Secretary, Department of Home, Kohima, within bracket, respond number 4, appears to have entertained the second application of the appellant, which was submitted on 4/12/2021. Full stop. It is it appears that on this same day, i.e. on 4/12/2021, comma, the Undersecretary to the Government of Nagaland, comma, Home Department, comma, Police within bracket, inverted comma, B, capital B, branch, had forwarded the application of the petitioner, the appellant, to the Kendriya Sainik Board, comma, Government of India, and the name of the appellant was recommended by letter dated 9/12/2021 by the Kendriya Sainik Board, Government of India. Full stop. Therefore, comma, the court finds that that in entertaining the application of the appellant, comma, there are 3 violations of the conditions mentioned in the advertisement. Full stop. Firstly, comma, the application was entertained after the last date of applying. Full stop. Secondly, comma, the application of the appellant was entertained, although it was not sent in the manner prescribed, which is by sending it through registered post. Full stop. Thirdly, comma, the respondent number respondent number 4, the Special Secretary to the Government of Nagaland, Department of Home, Kohima, by accepting the second application of the appellant on 4/12/2021, comma, is deemed to have accepted canvassing of the appellant for the post. Full stop. If the Department of Home desired that applications should be accepted even after the date of advertisement, comma, the appropriate manner to do so was to extend the period of applying by issuing a corrigendum, or to scrap the initial process and to issue a fresh advertisement for the class 1 post with which this with which the court is concerned in this appeal. Full stop. As per the representation of the applicant, which was made on
22/11, 2021.
huh?
Page number 1.
Yes. Representation of applicant dated 22/11/2021, comma the appropriate authority in the Department of Home as well as in the Department of Ex-Servicemen Welfare and Resettlement, comma Government of Nagaland, was made aware that between the date of advertisement and the and 22/11/2021, comma, more officers would have retired and were otherwise eligible to apply. Full stop. Therefore, by not extending the time for applying, comma, the authorities in the Department of Home, Government of Nagaland, had adopted a pick and choose policy for the appellant, and in the process deprived other eligible persons who might have retired between the date of advertisement and acceptance of the application of the appellant to apply. Full stop. This process adopted in respect of the appellant cannot be said to be a transparent process in the or in the benefit of a larger section of the society who could have applied had the change in date of application being notified. Full stop. Therefore, the court is of the considered opinion that the decision of the learned single judge in the impugned judgment and order dated 27/2/2024 warrants an approval of this appellate court of this in this appeal. Stop. We endorse the finding of the learned single judge that the entertaining of the application of the appellant without extending of the due date amounts to violation of the rights under Article 14 and 16 of the Constitution of India. And accordingly, the interference with the appointment order of 21/7/2022 in respect of the appellant is not liable to be interfered. Full stop. Accordingly, this writ petition fails and the same is dismissed at the admission stage without issuance of notice on the respondents. Next paragraph. No, just not yet over. Full stop. Insofar as the cases cited in the bar is concerned, comma, we are unable to concur with the submission of the learned counsel for the appellant that this is a case where the unsuccessful candidate has challenged the selection process. We are also unable to accept the submission of the learned counsel for the appellant. That which paragraph in the second case? Para 3, you said? Para 3.
Varieties of facts. Para 14 to 18.
14 to 18. This was a case where the appellant, so the respondent number 1 had participated in the selection process, knowing with prior knowledge that the selection was not being done strictly in accordance with the qualifications mentioned in the advertisement and in the service rules. Full stop. In this writ petition, no document has been shown that the respondent number 1 was duly informed by the authorities in the Department of Home, Government of Nagaland, that they had permitted the appellant to apply after the due date of applying, after the last date of applying, and that despite rejection of the candidature of the appellant, his second application was also entertained in gross violation of the terms and conditions of the advertisement, which are already referred above. Full stop. Therefore, this is not a case where the selection process is being assailed by the petitioner, by the respondent number 1, but it is the gross illegality in the manner of selection and appointment of the appellant that was questioned by the appellant. Full stop. Therefore, the cases cited at the bar by the learned counsel for the appellant has no application in the present facts and circumstances of the case. That's all.
Lordship, I also may be.
Oh, I will stand closed in view of the disposal of the appeal. The I stands closed. And caveat, please discharge the caveat by Mr. Jimami.
For motion, item numbers 2 and 3.
Will issue notice, condemnation application.
She will accept notice on behalf of the respondent.
Okay. And Mr. A. Jimami, learned counsel for the applicant, issue notice on this application under section 5 of the Limitation Act for continuing the delay of 37 days beyond the period of limitation in filing the connected appeal. Miss
Yes.
Learned counsel accepts notice on behalf of both the respondents.
There's a sole respondent here.
No, there are 2 respondents.
There is read appeal 7 in 6. There is only a sole respondent.
In the first appeal, Your Lordship.
No, this is IA, first is IA 23.
Yes, I agree with you.
There are 2 respondents. Page 3, I am finding 2 respondents.
Lordship, page 3 is a reference to the writ petition.
Oh, acha.
Page
Okay,
two.
for the sole respondent, okay. Then make it applicants, as applicants and sole respondent. How, the notice of, how many days, within how much time you will find objection?
3 weeks time. Lordship.
Three, okay, notice, we say notice determined in 3 weeks. Issuance or accept notice. So affidavit in opposition, if any, be filed at least 1 day prior to the next date of listing. List after 3 weeks.
In full, there are more respondents.
There are 4 respondents. Okay,
In five.
okay, you are accepting notice for all 4?
No, Lordship, in, for the private respondent, only. Respondent number 3.
For respondent number 3 in
Yes.
the second case.
Yes, yes.
In the second case, this is a delay of same 37 days. She is accepting notice for respondent number 3, and you are accepting for
1 and 2.
for 1 and 2. And so mentioned on council accepts notice for 1 and 2. And there is one more. 4 respondents or 3 respondents?
Yes, my lord. Yes, there's a private respondent. There's a private respondent.
So for them, there is no advocate?
3. There are only 3 respondents.
3 respondents, ma'am.
Oh, okay, only 3. I'm sorry. I'm sorry, only 3. Same order.
From the supplementary cost list for motion item number 31.
Yes. I think because of, perhaps because of lunchtime. Okay, we'll take it up at 2 then.
Cabinet decision was never reversed. They are challenging, they say that the condition was never known to them. What the cabinet decision?
We'll take it up at 2. Just wait for some 5 minutes. Okay, we'll receive it too. You're locked in. Office wants us to work.
Lordship, yes.
I'm very much ready for the supplementary. To the lordship.
Clause 13, 14 लो जी।
May please, my lordships. The appellants are before the Honorable Court Lordship in quest of their right to life under Article 21 of the Constitution of India. Lordship, what has happened is the petitioner, before appointment under the state cadre, under the state government, they were serving under NHRM, National Rural Health Mission. They approximately all the petitioners, they worked in between 10 to 19 years, and they resigned from their service in search of regular appointment as advertised by the respondent government. My lord will kindly come to advertisement dated 17/7/2020. That is at page 96. This is the crux of the petitioner's case.
Just a moment, before you came, I was asking for an adjournment to be taken up next week. Okay,
Yes,
okay,
yes.
okay.
Because she also did that.
No, it's okay.
No. Sometimes it used to go up, sometimes they used to come down by the serial number. So since it was at item number 31, it might come later on, and I just left to have a cup of tea, Lordship. I beg your pardon. So this
Without,
is
you went for a cup of tea without inviting others, other members of the bar.
the Lordship.
Oh, that is bad.
So this is the crux of the petitioner's case. At the backdrop of COVID-19, Lordship, the respondent government issued this advertisement. This is dated the 17th July. The office issued on 16th July, but in the newspaper. At that particular COVID time, Lordship, everything, every connection is done through newspaper publication. That was the only communication with the petitioner as well as whole department. So this was issued by the advertisement dated 17th July 2020.
Page
96. 96. Allow me to read out. Advertisement. In pursuant to notification number so and so, dated 26 June 2020, and Health and Family Welfare A, COVID so and so, dated 2nd July 2020. Applications are invited for recruitment against newly created posts on regular basis. Lordship, this is the basis of the petitioner's case. My lord will kindly appreciate this. Regular basis. Under the Department of Health and Family Welfare through the Department Recruitment Board in the manner prescribed below. Name of the post, staff nurse. Number of posts, 110. Post in various health units. Pay matrix level 8. Pay matrix 28,700 to 91,300. The terms and conditions and prescribed format of application can be downloaded from the department's website, Nagaland Health, Nagaland Government, in.com. 5. Last date of submission of application shall be 25th July 2020. Duly filled application in PDF format along with requisite supporting documents should be submitted through email to so-and-so.com. No application forms will be issued from the office. Incomplete application, if submitted, will be rejected summarily. List of rejected application will be published in the office notice board. Now, my lord will kindly come to page 97. This is the terms and conditions. That first one was issued in the local dailies, and this was issued on 16th July 2020. The department, within the department. Advertisement. In pursuant to notification number so-and-so, dated 26 July 2020, and so-and-so, dated 2nd July 2020. Applications are invited for recruitment against newly created posts on regular basis under the Department of Health and Family Welfare through Department Recruitment Board in the manner as prescribed below. Name of the post, staff nurse. Number of posts, 110 posts in various health units. Terms and conditions. The prescribed format of application can be downloaded from the department website. 5. Last date of submission of application shall be 25th July 2020. Duly filled application in PDF format along with requisite supporting documents should be submitted through email to so-and-so. NB. No application forms will be issued from the office. Incomplete application, if submitted, will be rejected summarily. List of rejected application will be published in the notice board. Now, second page, Lordship, the terms and conditions. Page 98, eligible criteria. Those who have resigned from contractual service without any valid reasons during the COVID-19 pandemic crisis shall not be eligible to apply for this recruitment right. Here, a little explanation is that, Lordship, the appellant, the present appellant, had been working since 10 to, mostly since 10 to 19 years at the time. They were, the first one was appointed in 2005, way back in 2005. So what has happened is, there were so many who resigned even from regular service at that particular time, as your lordships in your wisdom knows that those who were adverse to COVID-19, many from regular services also resigned. And so we were in such a circumstances where we have been working for 10 to 19 years in service under NHRM, that is centrally sponsored scheme. So those who resigned from the contract service under NHRM, they were not allowed to apply for the recruitment. So that is very clear. And since we were all the appellants were working under the NHRM for more than 10 to 19 years, we applied. Lordship, then at 3, I'm only showing my lordship, the operative portion. Down at clause 3, reservation post. The existing reservation of posts for backward tribe, etc., shall be followed wherever applicable. Now, why I'm reading out this is that Lordship will kindly appreciate that in Nagaland, there are 8 backward tribes, identified backward tribes. So in all the appointment, recruitment, certain posts are reserved for the backward quota, as backward quota, Lordship. So why I'm referring to this is that, Lordship, here the advertisement itself is a regular advertisement. Only in regular advertisement do this existing reservation policy is applied. So this is a regular advertisement. Then my lord will kindly come to 99, page 99. C, 99C says, shall sign a bond not to engage in private practice. This is one, the terms and conditions of the appointment. D, the selected candidate shall report to the respective chief medical officer, medical superintendent within 7 days from the date of issue of the appointment order. Failure to join within the stipulated period will forfeit the engagement. So this is the terms and condition. My lord, I have made myself clear to that portion. That it is a regular advertisement, it is a regular terms and condition. In other contract or whatever engagement, temporary or whatever, reservation policy is never implemented in any recruitment. That is one aspect I would like to impress my lordship, because that is the crux where the problem started. Now, page 100, E. This is the corrigendum. This is the corrigendum issued on next day. On 17th July, this corrigendum was issued. And this corrigendum is published in the newspapers. This is for laboratory technicians and for the post of Ayush AMO, medical officers. This corrigendum dated 17th July 2020, Lordship. After the publication, the next day they issued this corrigendum. Then we are on this. On the same day, 17th July, this is the crux of the petitioner's case. Page number 101. We have impugned, we have challenged the clause C. What has happened is, my lord, during COVID time, all the corrigendums, addendums, everything was published in the newspaper, and that was the only communication between the department employees as well as new recruitment or whatever. So what has happened is 101 by annexure E1. This was dated 17 July 2020. This was 17 July 2020. This is a non-existent corrigendum that was issued to victimize the petitioners, and we are on this, lordship. This is very relevant to this case. We are on this corrigendum in connection with the advertisement dated 17 July 2020 that came out in the newspaper, lordship, referring to that. On the upcoming recruitment drive for various posts, the following corrections are hereby made to the undermentioned posts, read as follows. Lordship, you kindly see here clause C below. These are the marks that has been indicated. Clause C. We have challenged this. That regular appointment that they issued in the newspaper, regular appointment in case of OT technicians, ECG technicians, laboratory technicians, radiographer, X-ray technicians, and staff nurse. We are concerned with staff nurse, lordship. To be read as temporary appointment. This was never within the knowledge of the petitioners. They have admitted before this honorable court that they did not publish it in the daily newspaper that was already submitted before this honorable court. But they say that they have uploaded this in the department website, which is absolutely false, lordship, because neither the appellants nor any employees were daily COVID update. All the employees went to department website for each and every uploads or whatever. This corrigendum was never uploaded in the department website, and out of blue, after the appointment of the petitioners, appellants, lordship, whether petitioners or appellants, we are petitioning. So this was never uploaded anywhere. It was never within the knowledge of the petitioners, but out of blue, suddenly they claim that they issued on 17. This was never published in the newspaper like any other. Even on the same day, for IUHMO and for laboratory technicians, they issued in the newspaper corrigendum on the same day. But this was never published in the newspaper, never did they publish in the department website. This next year E, page 101, lordship.
Yes.
So this one. So here, violation of principle of natural justice comes in, because at that particular time, they never knew about this corrigendum, but in order, probably they have backdated so that they could victimize the petitioner appellant's, lordship. So, lordship, we kindly see that they changed the circumstances of the advertisement terms and condition from regular appointment to temporary appointment with malafide intent, lordship. Now, after this, page 102, annexure E2, page 102. This is also the addendum. Any modification, addition was always.
Perhaps if you allege malafide, Then perhaps you'll also require to implement the concerned officer as a party.
I have already included the exponents. Of course, they have been, the lordship will kindly come to each.
By name, we don't find any officer. Because you are alleging malafide.
4. Respondent number 4 is the one who issued it.
No, this is my office. This is not my name. Malafide is personal.
That will just, that will just, I'm just trying to relate to my
Yes,
lordship's factual position. So 19 July 2020, they issued another addendum saying that the advertisement pertains to indigenous inhabitants of Nagaland only, and that backward tribes quota shall be met in accordance with the terms of the existing reservation policy of the government of Nagaland issued from time to time. So what I'm trying to impress my lordship is that this is a regular appointment, advertised on regular basis. So this addendum was also published in the newspaper. All the addendum, corrigendums were published in the newspaper, except this crucial addendum they claim they issued on 17 July, which was neither uploaded, which was never published. This is the only lone corrigendum that was never within the purview of the public or the appellant petitioners. Now, against the advertisement, even after issuing as regular appointment, regular basis, lordship APNA, that is the Unemployed Trained Nurses Association, approached this honorable court challenging the advertisement. And in this Untrained Nurses Association, the petitioners, appellants, present appellants are also a part of that, lordship. That is 103, page 103. We approach this honorable court praying that for direction to quash the advertisement. That was also regular appointment. To quash the advertisement and to appoint the petitioners in the newly created post on queue system. Queue system is lordship, it's unfortunate, but since the inception of 1988 service rules, queue system, since 1988, queue system is in practice, existing practice, where the respondent used to appoint the trained nurses without any advertisement, and as per seniority list, they used to appoint the staff nurses as per queue system. So the petitioners, present appellants, as well as others approached this honorable court. All the Untrained Nurses Association who were not regularly employed approached this honorable court in writ petition civil number 93/2020. Annexure 103. Approached this honorable court for quashing the advertisement and praying before this honorable court inter alia to fill up the newly created posts as per existing queue system. Inter alia, lordship. So what this honorable court did not interfere with this advertisement, and my lord will kindly come to the operative portion is at page 140. This honorable court did not interfere with the advertisement, directed the respondent to go as per the advertisement without that interference. That will be a measure. And what has happened is,
Page number, you are referring to which page? Page number?
Page number 103 is the
103, this judgment you have seen. Yes.
petition 93/2020, where the
Yes.
petitioner as well as all the untrained nurses approached this honorable court in this, that to quash the advertisement, that is also on regular basis to quash it and to appoint the petitioners as well as untrained nurses as per existing queue system. That was practiced. And in fact, my lord will appreciate that we are the first batch in the history of staff nurses to have recruited through regular process advertisement. This also, my lord, will kindly appreciate. So the operative portion is page 140. 140, last paragraph. As such, I find nothing illegal in the impugned notification and the impugned advertisement in particular. In any case, as stated above, the validity of the second part of the case of the petitioner depends on the result of the findings made in the first part. Because when it has been decided in the first part of the petitioner's case that appointment through queue system is not within the constitutional scheme, appointment to the post of 143 staff nurse created by the decision of the first cabinet sitting on 11/6/2020 would not have been allowed through the queue system alone. Furthermore, page 141, Lordship, from the reading of the minutes of the two cabinet meetings and the notification issued hereafter, it appears that it is an emergency and one-time measure taken to deal with the health issues of the people of the state arising out of the COVID-19 spread. Therefore, this court has no inclination to interfere with it. That is the advertisement, my lords. However, regarding the maximum age of eligibility, which is extended to 45 years, in the case of serving contractual employees, that is us, Lordship, I am of the view that the same relaxation should be extended to all trained nurses of Nagaland, considering the fact that many of them did not have the privilege of being appointed on contractual basis, and such opportunity to compete with for appointment comes very rarely. Therefore, the respondents are hereby directed to extend the same benefit to all the three nurses in Nagaland to enable the persons who have not applied for the selection process due to overage. My lord will kindly appreciate that. Due to overage, the respondents shall extend the last date of submission of application till 4 p.m. of 31/8/2020, and thereafter conduct the examination at the earliest in view of the immediate need of the medical personnel in the present situation. The extension of the date of submission should be published in newspapers and other medias so that the intended candidate for candidates all around the state may be able to know the same. The writ petition is disposed of in terms of the conclusion drawn, observation made, and direction given in. So we lost the case. Then, having no alternative, we applied. The respondents applied for the advertised post, Lordship. Now,
just a moment. By this judgment, the questions are answered in two parts.
Lordship.
First says that the queue system is bad. It's
Yes, that
unconstitutional.
is declared illegal.
And second part is that the
Age should be relaxed to 45 years.
so that is not considered.
Yes, that was not an issue. So, no, what I'm trying to impress my lordships is that at that particular point of time in 2021, our age was relaxed and it was raised to 45. That's why we could apply.
Okay.
Now I have annex. Anyway, I'll go by sequence, lordship. So after this, what has happened is more than thousands applied for the post, and about 300 something were shortlisted for the interview. Now, lordship, what has happened is absurdly, the respondent at annex page 152, after the advertisement in July 17 July 2020, the respondent absurdly, after this writ petition was passed and dismissed, they pick and choose 129 staff nurses and appointed them on queue system, leaving leaving aside the present appellants, present petitioners. That was later on discovered, Lordship, because during COVID time, there was no much connection. Then thereafter, interview was conducted. That was also published in the newspaper, Lordship. Interview to be conducted is at page 143. This is interview 9th December 2020. My Lord has seen it. Also, I would like to appreciate my Lordship. Post was 110 advertised, however, by addendum at page 142. By addendum, 19 posts were added and 129 posts were advertised. So it was raised to, enhanced to 129 posts.
This page 144 is which date?
143.
No, 144. This is the shortlisted.
Yes, Lordship.
This is which date?
There is no that, but this is the shortlisted candidates that was put from there. There are 300 and some, Lordship. I have stated in my, but 100 and. Yes. So plus. No. 387 candidates, both A and B together. 387 were shortlisted. I'm not saying it in different A. I'm saying that 387 candidates out of thousands who applied were shortlisted and interview was conducted on, which were all published in the newspaper.
So two groups will be 123 and 164.
Yes, Lordship. So
Okay.
if we plus it, Lordship, it
Yes.
comes to 387.
Okay.
So interview was then issued in the local dailies 7 December 2020, page 143. Is that is to be held on 9th December 2020 onward, Lordship. Through Zoom meeting, Lordship. So the shortlisted candidates are from page 144 to 151. Then, in the meantime, even after this honorable court declared that queue system is unconstitutional and illegal, they appointed 129 other remaining posts and those retirement expiry posts that arose in the department, they appointed 152. 15 December 2020, the appointment order. These were also the petitioners in the previous writ petitions, Lordship, where this honorable court dismissed the writ petition upholding the advertisement. So these 129 were appointed through queue system. That is 15 December 2020. Page 152 to 159. 129. queue system on regular basis, Lordship. Though it is stated as appointed, this is a regular appointment. Then, Lordship, in the meantime,
Just a moment, where do I find this? Page 152 is a queue system. Where do I find that? Page 152, you said it is a queue appointment.
yes, this is the 129 appointment.
On-
Without advertisement, they appointed this 129.
This is without advertisement.
This is as to the. Where was that?
Then we are also one-time measures.
No, just let her complete, we'll come to you.
Not confusing, you are trying to confuse the court.
No, don't
The
worry.
court declared unconstitutional, they be confused, and after the advertisement, they issued this, half of the petitioners who were also writ petitioners.
One has to be glad if one of your brothers can mislead the court with his submissions. You should be glad that it is, well, it's okay, we'll come back to you. We'll come to you. Because it distracts our line of thought.
Lordship. So, from page 162, 165, I have just annexed some to substantiate that after the interview that was conducted, the appellant petitioner continued to work under NHM on contract basis, while awaiting the result, Lordship. So 162, 165 are their certificates where they entered, they were COVID positives, and some of them they entered even ICU. So I am just trying to impress my lordships that they continued in their respective NHM service on contract basis after the interview on 9th December 2020. Then, while awaiting their result, Lordship, the respondent issued this 166. Their appointment orders, Lordship. It's very absurd and it's very unfortunate that they issued this, and the petitioners' appellants were taken by surprise and shocked, because this appointment orders is quite contrary and in contradiction to the advertisement, the terms and conditions of what they have advertised, Lordship. I may be allowed to read out. In pursuant to letter number so-and-so 12 February 2021, the following GNM, BSCN are hereby temporarily engaged to the post of staff nurse and posted to the undermentioned places against new post creations, retirement vacancies at level 8 of the new pay matrix, ROP 2017, pre-revised pay band of rupees 52,000 to 20,200 with grade pay of rupees 2,800. In fact, the pay band is of regular cadre pay band, Lordship. The engagement shall be as per following terms and conditions. This is the new terms and conditions that we are against, Lordship. And this was new, and we were shocked to discover these terms and conditions while awaiting result. They did not declare result, and just at a speech, all of a sudden they issued this appointing the present petitioners appellants, Lordship. 1. The engagement shall be for a period of 12 months, regular turn into 12 months, Lordship, only, or till regular appointment is made through NPSC, whichever is earlier. 2. The appointees shall have no right to claim for regularization of the engagement on contingency basis on any ground whatsoever. 3. No type of P is also, Lordship. No sundry service, Lordship. Type copy is at page 166A, Lordship, for my Lordship perusal. No sundry service benefit such as earned leave, save for 12 days of casual leave, shall be admissible during course of 12 months contingency engagement. The engagement carries with its liability to serve in any.
Just a moment.
Yes.
Just-
Yes, my lord. So this advertisement, since I will not read out, here I want to clarify for the nurse at serial number 3. Here 124 petitioners and appellants are before this honorable court. 5 others did not approach this honorable court. 129 regular posts, 3. She refused the appointment. Serial number 3, I want to clarify. While 124 are before this honorable court and 5 others, they are not before this honorable court out of 129 posts. Serial number 3 refused the appointment. Then my lords will kindly come to page 167. Serial number 28 expired. Lordship, serial number 28 expired. Then serial number 35 resigned from service. Serial number 35 resigned. Then serial number 44, she refused the appointment order. Then the last one, serial number 99, resigned. So out of 29 posts, 5 of them, 2 refused, 2 resigned from service, getting other new jobs, and 1 expired. So 5 were out. So here before this honorable court are 124 appellants, petitioners, lordship. That is what I want to clarify before this honorable court. Now, my lord will kindly come to page 189. I just want to impress upon my lordships that their appointment, this first appointment, even if they happen to be in service, by date of birth, only 10 or 12 years is remaining to be in service, lordship, even if they entered regular service. Because 29/10/2005, this was the first appointment order of one of the petitioners' lordship. That was issued, type out copy is 189A, 89. So the first one is appointed in 2005, now already 19 years in service. So
No,
under
this-
the
Page 189.
189,
189A
89A.
cannot be pursuant to 2020 advertisement.
No, I just want to impress my lord that prior to this advertisement, they were serving under the NHRM, and almost 80% of them, they served around 10 to 19 years under the HM. They were made to resign after being selected under the SCAD cadre. So in quest of regular service, they were fixed under fixed pay for those years in between 7,000 to 15,000 under the central sponsored scheme. That is very clear. So I just want to impress my lord that they have been serving under NHM, but after the regular advertisement was made, everyone wants a regular service after those years. So they resign from their respective service and join the state cadre, thinking that they are regularly appointed. So that is what I would like to impress my lord. Lordship, then my lord will kindly appreciate that 178. This is the minus of the cabinet meeting. Relaxation of recruitment rules for special recruitment for healthcare workers. This is cabinet meeting. Then 179 is the petitioner's appellant's representation to the government. 189 to 181 also is representation. They went even up to Lordship, 183 is also the representation to the government. 185 is also the representation. I want to impress my lordships that they have gone up to fast unto death.
Which is that cabinet decision you are referring to?
Cabinet relaxation.
No, cabinet decision you said.
Lordship, I will come to that.
Uh, 78.
Cabinet 178.
Oh, achha,
Lordship,
178.
the minus of the cabinet meeting, this we have first is 91, page 91. This is the basis. This is the post creation. Clause 5 in respect of the appellant, page 91, minus of the cabinet meeting. And lordship will kindly see at the bottom, page 92. The cabinet further directs that this approval is in one-time relaxation of laid down rules and procedures for recruitment, regularization, and condonation of each. Further, this one-time measure is in view of prevailing situation in the backdrop of COVID-19 pandemic shall not be treated as precedent. So this is the cabinet meeting, first cabinet meeting, and the cause of action starts from there. Then lordship will kindly come to page 186R. We challenge clause 7, serial number 7, in respect of the staff nurse, 129 staff nurse that is to be sent to the NPSC. And this honorable court, in all diligence, state the impugned clause serial number 7 in respect of the petitioner appellants in the first writ petition lordship. In the interest of public service and on the approval of the cabinet by the cabinet memo so and so dated 26/5/2022, the governor of Nagaland is pleased to notify the following posts to be recruited through a special recruitment drive as indicated below. So serial number 7, this honorable court state this one. while pending the writ petition, Lordship. Lordship, I made myself clear.
Yes, yes.
Then I will just, my lords will kindly come to page 41. Page 41. Page 41 to B are the resignation letter. This is just to substantiate before this honorable court. These are the resignation. After they were selected on regular basis, the petitioner resigned from their service under NHRM or NHM. Now it has been redesignated as NHM. Sure. So 41 to 43 are their resignation letters. Lordship. And here in the 42, page 42, it clearly says, with due respect, I wanted to bring out the above mentioned subject that, Madam, I have been serving under National Health Mission for the last 15 years as staff nurse, and I want to pursue my career elsewhere. May I therefore request you to kindly accept my resignation with effect from 21/4/2021. Madam, it has been an honor to have served under your esteemed authority. Thanking you in anticipation. So these are the three resignation letters. Then page 44. I want to show this honorable court that here are the 11 annexure 3 to 3J are the date of birth certificates who cannot way back into 2021 on the relaxation of 45 years. They appeared the advertisement examination. Now, this I have annexed to substantiate. Here are 11 appellants who have crossed 45 years of age. This is very absurd and
Which page? Which page?
44 to 54. 45 to 49 years by now. Where will they go? Can a welfare state treat its employees, use them and discard them policy, Lordship? So here I want to impress my Lord, and in the next step, I will be placing before the Senate court all the, because of bulkiness, I did not annex here, but all the date of birth certificate here, except 26, they are below 35. Otherwise, all have overage. And supposing if they fail in the second NPSC recruitment, Lordship, where will they go? Where will they go? This is the crux of my case, placed before this honorable court on compassion, even on humanity ground, Lordship. 35 years of age, below only 26 of them, I will place before this honorable court. Otherwise, every one of them has already crossed 35 years, and PSC is 35 years. My Lord, that is very specific. So these are the overage who have, by even now, even assuming that the advertisement, the NPSC make an advertisement, it is already overage that they can no more apply. Then Lordship will kindly come to page 55. This is a scheme issued by the central government in 2021. Page 55. My Lord will kindly come to clause 17. We are again relying on this. 77, page 56. 56, 17. This is issued by the Government of India Ministry of Health and Family Welfare, MEP section. This is dated 3rd May 2021. This is issued to all the additional chief secretaries, principal secretaries, health, medical, education, all state UTs, subject augmenting human resources of COVID-19 regarding. This is sent to all the states. Lordship, I will come to clause 17. the central government recommends to state UT governments to consider giving preference in regular government appointments of health professionals through the respective public service commission obliques. This is very important, Lordship. Other recruitment bodies for those health professionals under this special scheme who completed a minimum of 100 days of COVID-related duties. Here, the petitioners are not only 100 days, but the whole starting from 2020 when the COVID started till 2000, around till 2021 and 22. It's not 100 days. They have been serving more than around 2 years. Lordship, we kindly appreciate that. So here, Lordship will kindly appreciate that. I want to. What happened? What has happened is, Lordship, this is through their respective commission or other recruitment bodies. So we, the appellants, fell under other recruitment bodies. The special recruitment drive has already been taking place during COVID time by regular advertisement. The petitioner cannot be forced to go through another recruitment through NPSC as a special recruitment drive. In all human probability, Lordships will kindly appreciate that. Can NPSC, that is Nagaland State's highest recruitment body, conduct special recruitment body by giving 95%, 95.7 extra marks to a class of candidates, not admitting but even presuming, to the COVID duty, those who were under COVID duty. They want to conduct a general advertisement whereby a class of people will be given 95.7 marks extra. I will take my Lordships to that portion. That's 6 months. Lordship will kindly come to paragraph 11 of my writ appeal, page 14. It has been annexed in the writ petition. Where is it? Just I will read out that there is a notification. So many I'm unable to. 24. Just yes, Lordship. But I will just read out from the paragraph 11. It is also, there is an annexure, but just I have written exactly that as absurd as it is, the special recruitment drive through NPSC and NSSB in an open advertisement carrying a total of 487.5 marks, total marks in general. Allocation for general candidate and out of it, taking away 95.5 marks from general category candidates to appease a class of those candidates who served the health care system during pandemic in NPSC, the highest recruitment body in the state. Itself cannot pass the scrutiny of Article 14 and 16 of the Constitution of India. The allocation of marks stands indicated. Lordship, written exam 50%, weightage of COVID duty 25%, weightage of work experience 25%, interview 12.5%, 95.5% out of general candidate. Even presuming, not admitting lordship, but even presuming, can in a general advertisement, this kind of how many special recruitment they will keep on doing? Special recruitment has already been done, and I have stated that we are the first batch in nursing history where we were legally recruited under regular recruitment, lordship, special recruitment drive. So, lordship, now we were recruited as per calling application as per law. But we have become rather illegal, and the others have become legal. Others who have similarly situated persons, all under an HRM, by what authority they have pick and choose and appointed 129. This is also just for comparison and contrasting, lordship. Actually, this is the crux of my case, and I am saying, I am praying before the Honorable Court, until unless this impugned judgment order is stayed, lordship, the petitioners will be fundamental right under Article 21, right to live, along with their families. Where will they go, lordship? This is, the learned single judge has been incompassionate enough to where this kind of case has been dismissed. When we are in no longer to be appointed in service also, our age is already barred. As I have stated, due to bulkiness, I have not got, but I'll be present before the Honorable Court, lordship, all the candidates, all the applicants that of birth certificates. Only 26 of them are below 35.
Last submission about lack of compassion, that is something we are not appreciating.
Go beyond the compassion.
Lordship.
That is something we are not.
Lordship.
We will not
But
expect.
just basing upon the fact of the factual position of the petitioner's circumstances. So until unless this Honorable Court stayed the impugned judgment order during the pendency of this writ appeal,
Because-
lordship,
Because
the
if you look at my video about every week, at least once a week or twice a week, I tell the learned lawyers who are arguing before my court,
lordships.
I tell them one thing. Few days back, I had some ailment. I was compelled to take a leave for 4 or 5 days. And in the process, when the doctors checked me up, they gave me a very stunning news. They told me that I did not have a heart. So when we are in this chair, we are heartless, devoid of heart.
During the pendency of this writ appeal, lordship, I just humbly put for the Honorable Court that the impugned judgment order, that the writ appeal is pending. That is my humble submission.
Okay, but one more question. You see, having accepted the appointment, can you assert that?
At that particular point of time, when it was issued, lordship, all the petitioners are respective, I have pleaded in my writ petition. That will be decided by this Honorable Court, but what about Any agreement is with the person. The terms and conditions. So the petitioners, the beggars cannot afford to deny. And it was in one, beggars cannot be choosy lordship. That will come later on, but at least with circumstances. Otherwise, lordship.
Perhaps you have not seen beggars at certain places. You visit, if you want to see that beggars are choosers, you better visit certain temples, and in Gauhati, especially Sukreshwar temple. They will not accept whatever you give. And on certain days, when people give them food, there are certain days under Hindu beliefs when they offer food to the beggars. You have to give them a choice what what you will give. Otherwise, they will not come and take.
So lordship, just my humble submission before this honorable court is that any time since the writ petition has been dismissed, lordship, our post is likely, so I'm just seeking only 24 posts to be suspended, otherwise 5 posts that those who have resigned out of 129, 5 posts that they can send to the house planner and that, at least 124 petitioners. On the basis that the state, as a welfare state, my learned counsel for the state also should have the diligence, at least when we are overaged, to even apply. In case
Every recruitment rule will have a what do you call clause permitting you to apply for condonation of age.
lordship, here 35 is the for scheduled tribe 35, and 37 for those who are employed. Besides that, there is no more relaxation for MPSC.
Not beyond 37.
No.
Okay.
Beyond 37. So here 80% has already become overage. Lordship.
Yes.
But they did not do that.
Let him complete his part.
Oh, Lordship. There was a very particular situation.
What is this called? Nagaland?
Nursing Service Rules, 1988.
Actually, 2 was that. The one.
This is schedule.
Schedule 2. Was that.
Clause F. Clause 10.
Oh, Lordship, we have not denied the fact. Prior to the call, it was done through because of the acute shortage of manpower, the cabinet had to see the petitioners, the petitioners have not challenged the second cabinet member. Where they explain all the more. Now, Lordship, may kindly come to.
Where is that second one?
Second one is in my affidavit in opposition, Lordship. Lordship will kindly come to page 214, annexure 1 of the affidavit of respondent number 3 and 4. There are two cabinet siblings, Lordship. So I want to segregate these two cabinet members. If we go back to the first. Cabinet member was notified. Page 91. And actually A1 of the read agreement. Page 91. This is 12 June 2020. This is the first cabinet memo. And this cabinet sitting was held because of the privileged situation of the COVID pandemic. This is cabinet memory. Where post-creation were done, especially for medical department. There was acute shortage of manpower.
This is only a cabinet memorandum, right?
Yes. Now,
And where is the notification pursuant to this?
yes, yes, I'll come to that also. Now, motion may kindly come to clause 5, the last paragraph. Creation of 142 posts of staff nurse. The further paragraph is Lordship. The cabinet also approved the appointment on the existing queue system of the nurses while ensuring judicious deployment of just and fair manner in the hospital health centers. The existing instructions on reservation of posts of the backward tribe shall be followed. So 143 posts were created also on 12 June 2020. How the recruitment to be done, Lordship, no mention was made in the first cabinet member. Lordship, then coming to page 1214. Yes. Now the second cabinet, page 214 of the appeal memo. 214. This was never annexed to the written. So we have to bring on to the notice of this court, the second cabinet memo. This is cabinet memo dated 25th June 2020. Lordship has found, Lordship. Meeting held on 23 June. It was minuted on, meeting was held and minuted on 25th. Lordship, may kindly come to serial number 5, clause number 5. Creation of 78 posts of staff nurse, 143 plus 78. Previously it was 153, now 78 added. That is 281 posts. So altogether, only in respect of staff nurse, 221 posts were created. 143 plus 7. Lordship, the most important part, the second page, page 215. This is the where the whole how the recruitment should be done, Lordship. Page 215, Lordship. I may be allowed to read, Lordship. The cabinet further directs that the first part is the post creation. Second is how the recruitment should be done. All the newly created posts should be filled up by the Health and Family Welfare Department within a month's time with proper advertisement. While filling up the posts, due weightage should be given to the marks obtained by the candidate in the qualifying degree of the university, medical college, and years of work experience. The interview panel should include independent experts from outside the state. So this clearly states that this is an irregular recruitment to be done to tackle the COVID. Manpower was required at the time. B is very important. The department should clearly indicate that this appointment will be temporary and regular recruitment shall be conducted through special NPC recruitment drive. This is the cabinet decision, which they have considered. This is the decision of the government, Lordship, a policy decision of the government. Now, Lordship, regarding the queue, all the APNA, the first lead petition, 93 of 2020, when the Lordship. Come to Lordship, Lordship, can you come to page, the same page 215, clause E. For the purpose of staff nurse and as per the recommendation of the Manpower Rationalization Committee, MRC, the department should fill up 50% of the posts of the staff nurse from the queue of former nursing diploma graduate, and the remaining 50 should be filled up through direct recruitment and open competition. For direct recruitment posts, the existing reservation of posts of the backward tribe shall be followed whichever applicable. So, when the advertisement was, the commissioners, where they will send us, the challenge, it cannot be 50-50. Since 100% queue was going on, it should be given to us. But the court said, this is a one-time rate. Accepting the emerging requirement of manpower. So, the single bench in the PVC bank hold the decision of the cabinet. 50% will go through direct recruitment. But direct recruitment to be done by the department within 1 month time. But this appointment will be temporary as appointment is level 8. A is level 8 of the staff. They come under the period of officer. So that was a decision of the cabinet. Now, Lordship, may kindly come to page 95. MHC. Lordship, I'm going to take us sequence. I will treat even better. 12 June, cabinet decision. 15th June, cabinet 2020, cabinet decision, Lordship. Now this is 5th July 2020. Now, how the recruitment should be done as per the cabinet decision? I may be allowed to read, Lordship. This is 5th June. 5th July 2020. That is after the cabinet took the decision on 12th and 25th June. This notification came out. On the recommendation of the cabinet by number so and so dated 25th June 2020, the second cabinet, Lordship, 25th June, Lordship. The governor of Nagaland is pleased to frame the following basic guidelines because there was only their service rule. So they have framed a guideline how the recruitment should be done. For recruitment and service condition of the medical officers, nurses, technicians, so and so. 1. All the newly created posts to be filled up by the Health and Family Welfare Department within a month time with proper advertisement. Same continuation of the cabinet, Lordship. B. 2. This appointment shall be temporary, fixed, and regular recruitment shall be conducted through a special NPC recruitment drive for all posts covering under the preview of NPC. It's very important too. So FSC guideline was framed. There was already an existing solution. How to tackle the situation at that point of time. This guideline was framed. So this itself speaks that this appointment are all temporary nature. Also, this is document used by the petitioners. Now, Lordship, the advertisement was issued on 16th July. Advertisement was issued on 16th July. 5th July, the guideline was framed. 16th July, there. Page 97 of the agreement. Page 97. Inadvertently, Lordship, we don't like, we have committed an error administrative oversight by because this was not in line with the cabinet decision and the guideline framed by the government on 5th July. This advertisement was not in tune with the 5th June of 2020 cabinet memorandum and 5th July of framing the guideline. So, seeing the error committed, we did not change. You see the language, page 101, the corrigendum. This is corrigendum dated 17th July 2020. See the language, corrigendum. In connection with the advertisement dated 17th July 2020, on the upcoming recruitment drive for various posts, the following corrections. See the language, it's corrected, not change. We did not change the rule of the game. The claim of the petitioners is that we have changed the rule. But it was corrected. Clause C. Regular appointment, clause C of the same corrigendum, Lordship. Regular appointment in case of OT technician, ECG technician, laboratory technician, radiographer, X-ray technician, and the staff nurse to be read as temporary appointment. And this has been issued keeping in view of the cabinet decision of June 2020 and the notification of 5th July. It's not that we just we came up with some new things. It's not an afterthought. The cabinet decision was already in place. The notifications were already in place. It was an administrative oversight. Now, Lordship, coming to that 129, my learned friend has been pounding on that 129. Pick and choose 152, page 152 of the appeal memo, Lordship. These are the appointees who fall under the user judgment and order of because the single bench in the representative has said you will be one time as a capital administration. So what has happened is and on page 152 is for the Q, Lordship. 152 of the agreement, page 152. Whereby my learned friend is saying that we have pick and choose somebody. No, these are as per government.
Please repeat again. There are 221 vacancies.
Yes.
Then there were only 58.
258. So as per the which are held by the single bench
So 129 was advertised, which we have already relied upon, Lordship, the 17th July advertisement, 129. And this 129 went to as per cabinet decision and this honorable goes on. So this should not be the issue before court. The issue should be their appointment.
Yes.
So appointment order was issued, Lordship, page 166.
Saying that page 152 is Q.
Yeah, Q.
Okay.
152, 150. This is Q. Because they were only 258 posts. So where will we fill up beyond 258? 129 went to Q, 129 to yeah. Now, Lordship, as already pointed out, Lordship, with regard to the appointment. This appointment order was issued as the 25th June, the notification 5th July, and the corrigendum and advertisement. We have not changed the mode of the appointment. We have not changed, Lordship. It was corrected. We should kindly appreciate the language used, corrected. And the person who issued the advertisement is the person who issued the issuing authority, the advertisement and the corrigendum. Lordship, may kindly come to page 97 again, Lordship. The authority who issued the advertisement, page 97 of the agreement. Principal Director, Dr. Procedural, page 97. Page 97, Lordship. The Principal Director.
Yes.
And page 101, the corrigendum again. The same person. Same person. Because being the HOD, he cannot make his own rules. He cannot make his guidelines. He has to follow what correction from the government. The government follows the guidelines. So there is no variation as far as the advertisement is concerned. It was all flowing from the government. Now, again coming back to the appointment order. Terms and conditions were laid out in they served for 2 years. When suddenly the government took a decision that this recruitment should be done through special admission. Yeah. This was a punitive decision. Lordship, may kindly come to the notification. Yes, page 186. When we notify. The dates that's mentioned in this letter. This is annexure or page 186.
Yes.
In the interest of public interest and on the approval of the cabinet by cabinet members, so 6, we should be 25th. But also, this is cabinet decision. 6 May, the governor of Nagaland is pleased to notify the following posts to be recruited through special recruitment drive as indicated below. 7 staff nurse. Since the level is 8, the pay level is 8, they come under NPSC. Now, Lordship, why this notification has been issued is keeping in view of the direction of the government of India. My learned friend has retired, which apparently is a new document was never a part and parcel of this in the written. Page 55. This document was never part and parcel of the written. But it's just
No, don't disturb him.
it's a new fee that takes lordship. But I will substantiate to the fee that I have raised.
Page 55.
Yes, this is the Government of India, Ministry of Health and Welfare, letter dated 3rd May 2021. I'll substitute this per hour. So under clause 17, I may be allowed to read again. Clause 17 says, the central government recommends to the state duty government to consider giving preference in regular government appointment of health professional through the respective public service commission. Lordship, this is very important. Through respective public service commission. You have to go through the public service commission. Slash other recruitment bodies, that is a Nagaland State Staff Selection Board. We have NSSB law. For those health professionals under this special scheme, it was a scheme framed by the government of India, who complete a minimum of 100 years of COVID-related duty. So, government of India say make a scheme for special recruitment for this COVID, so to say, COVID holders. Those who have worked with the public, selflessly sacrificing their life. So, Lordship, I may be allowed to refer to my document. They kindly come to page 216. Since there was already a direction, the government of India to make a scheme as a one-time measure. Page 216. We, the department, we propose the relaxation of the recruitment rules and the service rules. Page 216. Which in fact is not a subject matter in the regulation. So a direction came on from the government of India.
You're sure you'll not be arrested for this?
Lordship.
Are you sure you'll not be arrested for showing us this? Because in the top of it is written.
This has been approved by the cabinet.
No, I don't know. It is written secret.
Yes, this is a proposal was made on 13th May.
No, but it is secret.
Lordship,
You are permitted.
As a cabinet proposal, we send it to the cabinet. Once the cabinet approves, it's no more secret.
Okay.
Lordship, no one will be in trouble, Lordship. I can assure you that.
Okay.
So, Lordship, I kindly see this cabinet memorandum dated a proposal was made, Lordship. Cabinet memorandum subject relaxation of recruitment rules for special recruitment of healthcare worker. So, as directed by the government of India, Lordship, this proposal was sent for relaxation of the recruitment rules. And more particularly, Lordship, may I kindly come to page 217. The weightage of marks to be given, Lordship. Page 217. Quoted there in the appeal memo, but the percentage doesn't tell it. Because her percentage comes to 98 point something. But we are dealing with 100%. Because recruitment cannot be in some 0%. Her tabulation comes to 95.5. But as per our workout, it's 100%. Worship may come to page 217. 217. First, we propose for relaxation of the Rule 15, Sub-Rule 1 to Sub-Rule 7 of the Nagaland Public Service Commission. Because every public service commission has its own recruitment. So we have sought for relaxation of Rule 15, Sub-Rule 1 to Sub-Rule 7 of the Public Service Commission, Recruitment Rules of 2008, as amended from time to time, prescribed for selection to be based on written examination and an interview, with the latter constituting 12.5 of the written examination mark. In relaxation of the prescription for the specific drive, it is proposed that the selection should be based on the following. So how marks should be allotted? Written for everyone, 50%. Weightage for COVID duty 19, 25 marks. Weightage for work experience, 10 marks. Interview, 15. So total comes to 100%. So out of 100%, COVID duty, 25%. This weightage was supposed to be to those, including the petitions. Now, as far as the relaxation is concerned, Lordship, age on donation, Lordship may kindly come to clause 4. Relaxation of maximum age of eligibility as prescribed under Rule 9A of the Nagaland Health Service Rule 2006 and the corresponding rules, because they come under the nursing rules, Lordship. So age is 35. For other officers, staff, up to 45 years. For serving officers, staff who have been serving under NHM and SAC and NHK on contractual temporary engagement basis and also serve the health system during the pandemic. So 45 years was confirmed. Up to 45 years by this proposal. And this proposal was approved by the cabinet. Approval of the proposal. Yes, page 178, annexure P of the agreement. So the proposal, which was submitted to the cabinet, was approved. This is the government of Nagaland cabinet secretary.
Please come to page 217 again. Page 217, please come again. This age relaxation of 45 years
Yes.
is for persons who are serving under NHM, NS, ACS, or NHAK.
AIDS Society, then Naga Hospital Authority Kohima, and on contractual temporary engagement.
So these are only three persons. These are only three persons for whom relaxation is to be made, not for the nursing staff of the state government.
Those who are because they are not in the service of the state, as claimed by them. They are on contractual. During the COVID time.
No, but during the COVID time, they are still under the state health department.
On temporary basis.
On temporary basis, but under the health department. They are not under NHM, NHES,
Yes.
or NHAK. So therefore, this age relaxation would not apply to them.
Lordship, basically the language used, Lordship, it speaks differently, Lordship, literally, but it includes the petitioners also, because they've been serving during the pandemic. Healthcare system during the pandemic. So that includes even the petitioners. Lordship, the last slide. That is important. And also serve the healthcare system during the pandemic. And Lordship. If I'm clear with that, it includes even the petitioners. Yes. I'll just sum up, Lordship. But as far as this is the petitioners. They are aware of the capital. First, we need to we should indicate that as a payment market. And then because of the excessive of the solution, Because a recruitment beyond the will happen. The person was- There was inadvertent error of the officer who issued that. Coming to know the error. Because it's not for 2 years. Right? That's it. Now, this was challenged before the court saying that the petitioner did not do it. That's depend on the single bench order. Then the number 292. May kindly come to the operating part. Page 35. This honorable court, the civil bench has carefully examined the documents, the completion of the requisition, as well as how this recruitment is done. All the careful documents. There's a lot to be comparison 50. Page 35 of the epic memo. This is a judgment, Lordship. I'm coming to the operating part. Because the rest are we've got the submissions made. I've heard the submission made by the other classes of the rival parties and have perused the reports, including them already decided by the facts. The controversy raised by the petitioner is that they have not been appointed to the post of partners in terms of the advertisement dated 16/7, which there will be a big confusion because advertisement was issued by the department of 16. But published on 17. So that there's a little bit of variations between 16 and 17, which provides that recruitment was to be done on regular basis through department. It's their further case that the corrigendum said to have been issued on 17/7 by the principal director that making a correction to the advertisement by replacing regular appointment with that of regular was not published in the newspaper and not within their knowledge. The further case of the petitioner is that similarly situated person have been appointed through system, which is a violation of the petitioner in the petition have annexed the meeting minutes of the cabinet dated 11/6/2020, which was circulated by memorandum dated 6/2020, where 153 posts of governors were created for deployment in all district hospitals. The petitioner also annexed the notification dated 2/7/2020, by which 78 additional posts of staff nurse were created by the for public health center. The petitioner has further annexed the notification dated 5/7/2020, by which the basic guideline for recruitment and service commission of the health officers, staff nurse, technicians, and other parameters have been framed. The notification has a reference to the recommendation of the cabinet decision circulated by memorandum dated 5/6/2020. The state memorandum has been annexed by the state respondent in the contract as Material 1. A perusal of the same goes to show that it is regarding the decision taken by the cabinet in the meeting held on 6/2020. The cabinet, apart from including the creation of 78 posts of staff nurse, directed all the newly created posts should be filled up by the health and family department within a month's time with proper advertisement. While filling up the post, due value should be given to the marks obtained by the candidate in the qualifying degree of the university, medical college, and years of work experience. The interview panel should include independent experts from outside the state. It is further provided that the department should be clearly indicated that the appointment will be temporary and regular recruitment through special and peaceful recruitment drive. In respect of the post of staff nurse and as per the recommendation of the manpower restoration of the department, fill up 50% of the post of staff nurse from the queue of former nursing diploma graduates, and the remaining 50 should be filled up through direct recruitment and open competition. Therefore, on the basis of the direction of the cabinet, the basic guideline for the recruitment and service condition of the staff nurse, among others, was framed by notification dated 5/7/2020, wherein it clearly states that appointment to be made will be temporary, fixed, and regular recruitment shall be made through special and peace recruitment drive for all posts coming under the purview of the Therefore, it appears that the advertisement dated 16/7/2020 inviting application for recruitment against newly created posts of staff nurse on regular basis apparently was a mistake committed by the issuing authority. The same was rectified by corrigendum dated 17/17/2020 by the same authority who had issued the advertisement. Although the petitioner claims that they are not aware about the corrigendum as it was not published in the local daily, but the fact remains that the corrigendum was put up in the department website. Similarly, the advertisement dated 16/7/2020 require all intending applicants to download the prescribed format of the application and the terms and conditions prescribed in the department website. Therefore, the stand of the petitioner that they are not aware about the corrigendum cannot be accepted. Further, even if one is to accept that the petitioners are not aware, the fact remains that the recruitment was to be temporary recruitment only can be traced back to the decision of the cabinet in its meeting held on 23/6, and also the resultant basic guideline framed and circulated through 5/7/2018. The further case of the petitioner is that persons who are similarly situated have been appointed through queue system, and the same is in violation of the post direction policy WPC 23/. It may be seen that a coordinate bench of this court in its judgment on order dated 19/18/20 in the said petition was to view that queue system of appointment does not come under the constitutional scheme, and therefore, in violation of the equality clause as provided under Article 14 and 16 of the Constitution. However, upon perusal of the two cabinet meetings and the constitution they issued thereafter, the court was of the view that it was only due to the emergency situation and as a one-time measure, a decision was taken to deal with the health issue of the people of the state arising from the COVID-19 spread. As such, the court was not inclined to infer with the same. The same cabinet decision and the notification should thereafter have been questioned in the present petition, and this court being a coordinate bench cannot take a different view without referring the matter to a larger bench. It may be seen that the notification dated 15/4/2023 was issued by the state respondent pursuant to the dispute for filling up 50% of the posts created, vacancy of which of queue system. The petitioner have no challenge to said notification, nor they have made the appointed person as party to the and therefore there is no scope for this aspect. The letter was to the petitioner as well as a number of authorities in support of the claim of the petitioners. The case of A. Manjuri Supra, Ramesh Kumar Supra, and Tej Prakash and others Supra, pertains to impermissibility for challenging the rules of the game in the recruitment process. It may be seen that in the present case, no changes have been made in the rules of the game, and that it was only a mistake or an error that was rectified by the corrigendum. The rectification is also supported by the decision taken by the cabinet in this meeting held on 23/6/2020. Therefore, the authorities cited are found to be not relevant. The case of Asamlati Iyer Supra has been relied upon by the learned counsel for the petitioner in support of her submission that the writ petition cannot be rejected merely on technicality. However, considering the fact and circumstance and in findings derived at the authority cited in the is found to be not applicable. Claiming regular appointment is a mistake made in the Similarly, the case of Madan provides that earlier criteria for recruitment shall prevail over any subsequent criteria in view of what has been stated in the foregoing paragraphs is also found to be not applicable. Lastly, the case of Somesh Tapial and another has been relied upon by the learned counsel for the petitioner. First of all, that appointee are not in a bargaining position and therefore have any choice but to accept the appointment orders. But however, the same is also found not to be applicable in the present case. As already stated here in above, the selection and appointment of staff nurse through advertisement dated 16/17/2020 was meant to be temporary basis till regular appointment can be made through the special advice as decided by the cabinet in the meeting held on 23/6/2020. Therefore, the petitioner cannot insist that the appointment should be on regular basis as was advised in the advertisement dated 16/17/2020. It was further to be noticed that the post of staff nurse is a non-gazette post and at level 8 of the new pay matrix of RB of 2017. The mode of recruitment as prescribed in the service rule, that is the Nagaland Nursing Rules of 1998, is through the NPSC. The petitioner in the instant case were screened by the Department Recruitment Board in view of the urgency and shortage of manpower in the backdrop of backdrop of unprecedented situation arising out of COVID-19. Therefore, the petitioner, under the facts and circumstances, cannot have any legitimate grievance. Thus, upon due consideration of the entirety, I do not find merit in the petition and same is dismissed. The or pass earlier stands vacated, no cause. So, Lordship, the court, single bench, in all its matters, has carefully examined all starting from the back. No, by comments and motion. When the motion raise above the report to regularize a temporary appointment. When the scrutiny says the case of the petitioner is on that advertisement and the correction, not beyond. But they have gone beyond the Atma case, the 50% key. So this is another aspect of the matter. Because the same committed bench, when it's committed bench, it cannot be variation, which was segregated. The issue was segregated. But as far as the 129 is person is concerned, of course, we have gone through some temporary process as per the guideline frame. How will the cabinet do this?
Here's what we see what she applies.
Yes. As far as the present read that is concerned, there's no merit in the case for difference of this.
Yes. Anything in reply?
Lordship, here our case is that corrigendum was not issued. The learned single judge, how can he come to conclusion that it was? And my lord has also perused the previous that was uploaded in the department website. Till date, there is no uploading of that corrigendum. We did not know it at that particular time. We were treated like outcast. We were not even entertained by our own family and all the nurses. We ended up in the COVID hospital and one died. And we were, even in our own posting place, we were not even allowed to meet some people because we were like, as I said, treated like outcasts. Now at that particular time, if my lordship will prevail, till that corrigendum is not uploaded, all the cabinet decision memos where everything was done prior to the advertisement. My lordship, if my lordship will kindly appreciate that we were serving somewhere else and we were duped, fraudulently duped on regular basis. Lordship, they cannot produce the uploaded documents. It's not even available till date. Nobody in the department saw it, nobody in the employees saw it. No. And when we approached this honorable court, this in Atna's case in the petition 9320, it was not even uploaded. Every day we were scrolling the department. How can the learned single judge, that's why he is so confident that the learned single judge say that, how can the single learned judge say that we were basing our case upon this, that no corrigendum was issued. Lordship, we came to know only, and result was not declared. It was straight away when we were flung far areas treating COVID patients. This after advertisement in July, then in April, after 8 months, they said within 1 month to recruit, but after 8 months, while we were waiting for result, this was straight away issued. The appointment orders were issued. Now, my lord, at least give the credit or give the pardon of proof to the respondent. They cannot produce before this honorable court. All others were issued even on the same day on 17 for Ayush MOs and laboratory technicians. It was issued in the corrigendum. How can this honorable court of justice say that corrigendum was issued, lordship? Had it been issued, it should have been an issue even in the first writ petition, because we challenged the advertisement. One aspect, Lordship, one aspect, I pray before the Honorable Court. The petitioner should not be in more adverse position than when they approach this Honorable Court. All these corrigendums, everything, when we were on agitation, after we got the appointment order, since it was not in terms and condition of the appointment of the advertisement, we started having agitation before the court, and after our appointment only, we cannot swear before the Honorable Court taking God's name, but when we were on agitation, we came across all this notification. Otherwise, when we during COVID time, when we were treated like outcasts, how can we procure these documents? And all these documents were, whatever they have stated before the Honorable Court is after the advertisement. After the advertisement, nothing changed. Not corrigendum was not issued. My Lord will kindly appreciate. In the first, not admitting, but to go by the respondent's stand. They say that this Honorable Court declared queue system as unconstitutional. Let them show this Honorable Court how much as per the service rule, how much they have recruited. They have recruited through advertisement. Why we are the first batch in the history of nurses during such a drastic time we have been recruited. Why we are made to go for another advertisement that is special. First recruitment, special recruitment, as they have admitted, has already been done, Lordship. So here it may not, for them they can use us and discard us, but they have fraudulently duped us to leave our first job, and by now, all this after getting the appointment order, we came to know of our status. That is on oath I am submitting before this Honorable Court. Then we started, when there was some relaxation, upliftment, lifting the COVID ban, we started having agitation before the respondent government. Respondent number 1 and 2 did not file their affidavit, and they did not contest because they, in their diligence, knew what the respondent number 3 and 4 are doing. 1 and 2 did not contest in this case, Lordship, and they did not file their affidavit. Lordship, here I just want to humbly pray that if they can, after the court declaration that the queue system is illegal, they still keep on harping that this Honorable Court did not interfere. That's why they appointed in queue system. What was the basis of the selection? And here, my Lord, I humbly pray that if the Honorable Court did not interfere, the Honorable Court also did not interfere with the advertisement. They did not raise that issue. The advertisement, to go by the advertisement, it did not interfere, and the advertisement say regular appointment. So isn't that from both side of the view? If they can, after the Honorable Court judgment, they say that it was not interfered, so they just keep on going for queue system, similarly situated persons. Whereas we are recruited legally, then they can appoint others through queue system. Lordship, here what has happened is that, my Lord,
Answer is Malik. The answer is Malik Mazhar Sultan. It's the decision of the Supreme Court, Malik Mazhar Sultan.
That, Lordship, I have not gone through. I beg your apology. But here, my Lord will kindly appreciate that even the advertisement, if going through the scrutiny of this Honorable Court and writ petition 9320, if they have gone through the scrutiny of this Honorable Court and say that the Honorable Court did not interfere, what about us? The advertisement also went through the scrutiny of this test and scrutiny of this Honorable Court, and the court directed for direction to go by the advertisement. So they cannot change their stance, but can our stance be changed after going through the scrutiny of this honorable court? Lordship, at least give us the, we are all overaged, Lordship. 80% of the respondents are, appellants are, petitioners are overaged. At least give us, where will we go with our family, with our whole life service period? We are not able to even appear for NPS exam. I have placed the, on record. What about our future? What about our family? And 1988, since inception, not even once NPSC has been conducted. We are the first group. My Lord, I humbly beg that give us an opportunity to at least prove ourselves that we are, the advertisement has, our service has to go by the advertisement. When I pray and I beg, otherwise Lordship will be in dire consequences. They are saying that we have accepted our status when the appointment order were issued, but we did not know it. It was issued in April 2021 when advertisement was made, and there was no declaration of result. And this was when we were far aside, flung everywhere all over the district. This was issued, and whereas we in a position to even take legal recourse, Lordship. And I humbly pray, Lordship, Lordships, we cannot even seek new employment now, by now.
So there's a query. This 129 posts has not been notified. Advertisements has not come on. Advertisements for 129 posts
Yes, sir.
for direct recruitment has not come out.
No, because there was only this stay over.
So there was a stay order.
That's
Yes.
why, that's why.
In
And
the single bench, but that has been now
Yes.
vacated.
Lordship,
There's
just
a
one,
written
my
response.
humble one submission is that the petitioners were in a far-flung area from remote places, manning the health condition of the COVID patient. Now, when this order was issued only through WhatsApp, we got it. We did not even have, because we did not even have. And standing in our shoes, Lordship, if we challenge this, we did not like it, and that's why after issuance of this, we started agitating, and all these documents we were annexes only after we did not come even to Kohima. Only after we got our appointment order, all these documents that they are saying that they knew it, they know this all were procured after we went for agitation when the ban was lifted. We tried our level best, but we could not have even the time to challenge it before the honorable court. And just one aspect, Lordship, as a welfare state, if we challenge this appointment order, who will look after our family? Because if we challenge this, then the court will stay if it is illegal, it will stay. If it is not as per the advertisement, it is not as per the advertisement, but being in our circumstances, if we challenge it, our pay will be withheld because it will be stayed. So where is the condition of us being able to challenge even this Lordship?
Too many ifs and buts. If we start thinking like that, we'll not be able to think.
Yes, but we are helpless, Lordship. We are helpless because even in the near future, we are already overaged to seek even new employment. That's why just give us an opportunity. I just pray that our post will not be sent to NPSC when the case is pending. That is my humble submission before the honorable court. Lordship, I'm not asking.
We'll examine in pass orders.
more than-
It will be uploaded only tomorrow. Today we can't, because by the time we
Yes, sir.
dictate orders,
Yes,
it
sir.
can't be
Yes, sir.
done. Yes, Mr. Yalu. I'll pass orders.
Yes, sir.
Lordship.
Obliged.
Lordship, I'm for the respondent number 1 and 2, Lordship. In the earlier read petition, Lordship,
You're for 1 and 2.
I'm for the Chief Secretary and PNR Department, Lordship. Lordship, the petitioner counsel has made a certain submission that respondent 1 and 2 has not filed.
Then where is the affidavit?
Yes, Lordship, in fact, we have not filed an affidavit. Lordship, this is the recruitment that done by the department, Lordship. Had it been done by the NPC, Lordship, the PNR would have filed an affidavit. However, this recruitment was done by the department, and then the petitioner, they were challenging the advertisement and corrigendum of the department. So we are just up for tomorrow.
Lordship can produce the origin. It's never
Well,
uploaded, Lordship.
We'll pass
It
orders.
is-
By the time we dictate, it will be late. You can only get it.
Lordship.
tomorrow.
Lordship.
Yes, Mr. Yalu. We'll make it day after tomorrow, not tomorrow. Tomorrow we have certain constraints.
After.
Day after tomorrow. We'll just see that. All these matters which are rolled over today, we'll get it all listed day after tomorrow.
Yeah.
Because we have otherwise a division bench on Wednesday. So day after tomorrow, we'll take it up in second half. Oh, no, no, no. This is, today is sixth, seventh, eighth. Eighth, we have received a request from the bar. There's some program of the bar. Have less amount of cases because at 2 o'clock. Huh?
We are observing International Women's Day.
Yes, that's
International
right.
Women's
So not day after tomorrow, it goes to Monday then.
Monday.
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 Because we have we received request from the bar to accommodate that meeting. Okay,
Wednesday, Monday,
Monday.
all right.
So
Can it be at 2 p.m. or there will be full DB on Monday?
no, it will be.
That will be a full DB on Monday.
Okay, 2 p.m. Item number
Lordship,
113.
30. Respectfully, my lord, I feel that this Honorable Court will appreciate the low points where he is surely to get an honorable acquittal, given the facts and circumstances of the case in appreciation of the evidence on record. So Lordship, I feel a little guilty as a counsel also to,
No, no, not that.
Yes,
But
Lordship.
this other matters will go on Wednesday. You make
My
a
lord.
mention earlier, we'll upgrade and take it up. Next
My lord.
week,
My
we'll
lord.
upgrade and take it up. You just remind us.
so can the matter be listed on Monday, Lordship, along with the other?
Monday, we have a single bench, we don't know how much matters are listed. So for Mr. Iralu, we are taking up those matters. Other older matters will be taken up on Wednesday. On Wednesday, you just remind us in the morning at 10:30.
If not, your Lordship, this Honorable Court, I filed for bail also, but this Honorable Court expecting
okay,
that the
we'll
matter
take it
can
up.
be taken up early,
No, no, we'll take it up.
my lord,
On Wednesday, you please make a mention at
my lord,
10:30.
my lord,
Request us to upgrade the matter and take it
my
up.
lord, my
Correct?
lord. Lordship,
And just tell your big prosecutor also to be here.
my lord,
Correct?
Lordship,
So
bless your Lordships,
on Wednesday, you please make a mention.
my lords,
We'll upgrade and take it up, but also request your PP to be there.
my lords,
Oh, you are there? Okay, okay. Please be there on Monday. We'll upgrade and take it up. Oh,
Lordships.
sorry, Wednesday.